Good afternoon, good morning, everyone. My name is Manik Singhal, your host for the International Conference on SEPs and Standard and Patent Innovation 2025. It is my great pleasure and honor to welcome you all to the second South Asian Global Intellectual Property Summit 2025, organized by the Center for Development of Intellectual Property and Research and Naovina Development Intellectual Property and Research Foundation in collaboration with the Global Innovation Policy Center, and Open Invention Networks. Before we begin, let me briefly introduce you the conference. The International Conference on SEPs and Patent Innovation 2025 is a landmark initiative under the second South Asian Global Intellectual Property Summit. In today's world, where technology where technology standards such as 5G, the Internet of Things, artificial intelligence, and green technologies are shaping the pace and direction of innovation, standard essential patents stand at the heart of this transformation. The governance, licensing, and enforcement of SCPs raise complex questions that cut across intellectual property law, market competition, and global trade. This conference brings together patent law experts, economists, technologists, policymakers, industry leaders, and scholars from South Asia and beyond to engage in a critical dialogue on SEP licensing framework, FRAND commitments, patent pools, and competition law challenges. It aims to create a collaborative space where diverse perspectives can inform practical and inclusive solutions to SCP disputes, particularly for developing economies and underrepresented innovators. The theme for the session is From Standards to Solutions Rethinking SCP Governance for Innovation and Equity. Our theme reflects the urgency of building transparency, inclusive, and global harmonized SEP framework that not only protect innovation but also ensure fair, affordable, and equitable access to essential technologies. By fostering cross-disciplinary exchange and addressing emerging challenges in sectors such as AI, digital platform, healthcare, and sustainable technology, the conference seeks to contribute to the development of future-ready governance models that balance the right of innovators with the broader public interest. I would also like to explain about the CDIPR. The CDIPR, the Center for Development of Intellectual Property and Research, is India's first dedicated non-profit organization committed to advancing intellectual property rights. With a mission to democratize access to IP knowledge, CDIPR empowers creators, innovators, and enterprises to strategically manage and protect their intellectual assets. Its work is anchored in principles of inclusivity, sustainability, and economic resilience, striving to build a more informed and empowered IP ecosystem. Today, we are honored to be joined by Mr. Satyoki Kundiana, legal head at Nokia and a seasoned techno lawyer with extensive expertise in patents, industrial design, and SEP negotiations. His career spans IP prosecution, litigation, cross border transaction, and the full life cycle of intellectual property rights. We are equally privileged to have with us Mr. Dipendu Das, founder of the Center for Development of Intellectual Property and Research and the Naovina Development of Intellectual Property and Research Foundation. His vision and leadership have been instrumental in advancing IP education awareness and international collaboration, making initiatives like this conference possible. Gentlemen, we are truly grateful for your presence today and we look forward to hearing your valuable insights. I now invite you to take the stage from your opening. Yes. Sir, please go ahead.
Am I audible here?
Yes, sir.
Okay. Thanks. I thought it's Dipendu who's probably going to initiate the session, but let's let's kind of start a conversation which has been due in India, especially now that India really stands at an inflection point. Uh, uh, Not only because of the fact that we are seeing a lot of technological developments in India, which is obviously quantized by the number of filings at the Indian Patent Office, but also these filings per se seem to stand at the critical juncture of becoming foundational technologies for something much greater. Uh, am I audible here? I seem to like kind of hear some noise on the background, but I'm just kind of.
Yes, sir, you are audible. You're perfectly audible.
Okay. All right. All right. Thanks a lot. Thanks a lot. So, before we kind of talk about SCPs, it's important to understand the context here. And the context is this: that when it comes to foundational technologies, for instance, communication technologies, these foundational technologies lie at the premise of a lot of research and development, which means to say that companies and research institutions, they work for years and years in development of international standards. Why are they called a standard? Because through years of research is where you come at a solution which forms the fulcrum of an industry to move forward. And we need that fulcrum because that fulcrum is basically the premise of faster development, uh, convenient development, uh, adoption of faster solutions, etc., etc. Now, this example, I mean, if I were to exemplify this, the development of cellular standards from 1G to currently 6G, which is currently under research, is a fantastic example of the fact that institutions have handheld each other in development of these standards. What are standards? Standards are basically solutions. Those solutions are interoperable with other use cases, and those solutions form the crux of basically the coming or arriving at further solutions to use cases such as bandwidth, to use cases such as network drops, etc., etc. And it is because of these handholdings is where we stand, that we've got the cheapest data rates in India, we've got the fastest evolving telecom networks in India, and we are able to enjoy so many services. Now, the question really is this: that when a company participates in the development of a standardized technology, that participation has to be administered by an institution which is called a standard development organization. The objective of an SDO, or a standard development organization, which is an industry joined or an industry voluntarily coming into form, that body, is to basically ensure that the best technological solutions are included in the standard, and these standards enjoy wide acceptance in the market. Uh, at this juncture, it's important to understand that when it comes to development of these standards are both, the development itself is both risky and it's costly. For instance, the organization that I currently belong to, which is Nokia, we have to, or rather, we do invest hundreds of billions of dollars to develop cellular standards, which is to say, when it comes to a quantization, it's about 18 to 19% of the total turnover to ultimately produce these foundational technologies that become a part of the standard. Uh, and it is perhaps this research and development angle which explains that a lot of these solutions which are developed are basically, they don't make it to being adopted as a standard solution. A lot of those solutions are basically sunk costs or sunk R&D which has to be written off. So it's through this trial and error process of developing solutions and solutions and solutions, that's why one is able to arrive at an industry consensus driven solution which can be adopted as a part of a standard. That is first premise, uh, which is to say that developing a foundational technology is both risky and costly. And it is perhaps because of this reason that there are only a few companies that contribute to the development of these type of standards. Now, there has been several empirical studies to basically establish that when it comes to participate, the amount of participations across these SDOs, which are public record by the way, there is only a few dozen companies who have participated thoroughly, contributed a lot of solutions, and those solutions have been adopted as a part of a standard. Uh, when it so that places the perspective where a solution basically becomes a part of a standard. The second angle which comes into play is the fact that when an implementer or a person or an entity who's willing to adopt those solutions into its device or its use case has to basically use that solution in his or her device for the device to operate. Why? Because That solution itself forms the foundation of a device to basically work. What are the examples? The basic examples are a smartphone. A smartphone will not work if a cellular connectivity is not placed within it. A smartphone is not going to play let's say a video or an audio if encoding or decoding capabilities are not placed on the smartphone. If I take a step further, a payment operating services or a POS device is not going to operate if the cellular functionality is not placed on the device. So essentially, it means that foundational technologies are basically enabling devices as we move forward into IoT and smart things. Uh, Adoption of a solution which has got an IP behind it. Of course, these solutions which are built obviously have IP behind it, and because these solutions become part of the standard, the IP or the patent, the underlying patent becomes a standard essential patent, which means a patent which is essential to a standard. The adoption of this solution into a device basically mandates an implementer to seek an authorization from somebody who's developed it. This is basically placed under the law as well, the Patents Act as well. Uh, and the providing of the solutions are mandated by something, by a norm which is called FRAND, which is fair, reasonable, and non-discriminatory. Which is to say that these solutions to be adopted by an implementer will not be unfairly discriminated in terms of its adoption. And the authorization would, obviously, because years and years go by in basically building the solutions, a decade goes by, if I may say, in basically building a solution and that being deployed in the market. The actual costs of that R&D are only when licensing rates are placed onto the standard developer for him to basically uh, uh, um, absorb the R&D costs by the licensing revenues which come by. And the licensing revenues come by through a compliance mechanism which is called FRAND. And this is where disputes start, to basically say that while uh, so there are two basic ways of looking at a dispute. One is where an implementer refuses to pay for a solution which is a part of a standard or a standard essential patent being implemented on the device. And the second scenario, which is academic and is not basically established by empirical studies, is where an SEP holder is discriminating the adoption of a solution in lieu of exerting higher revenues. Let me be very clear, no court, no empirical study has basically established this sort of a behavior by an SEP holder. The reason behind is this, that these negotiations are bilateral. So all the compliance and check mechanisms are already a part of this process. And this is where I think my 10 minutes kind of end, and I'll just end this with a parable that I always go back to examples, and uh, and we've been a nation of storytellers, and this is where a very nice story comes into my mind, the story of Samudra Manthan, which is to say that there were two parties having rivaling interests, and those parties came together to basically further the world. And in the churning of the ocean, which is to say that determination of solutions which could drive the world, there were certain externalities which came into being, which is the halahala or poison. And beyond those poison came in the rewards of it. And it is this collaborative force or collaborative work spirit between two parties having rivaling or opposing interests that solutions can be built, solutions can be driven, and the rewards of those research and development can be placed onto both the parties, not in equal measure, but in equitable measure. And this is where I would like to, and these are the thoughts I would like to place for the panel to, deliberate upon, and wishing a great discussion, for this conference. My many thanks to CDIPR and Naovina and especially, I would like to mention Dr. Shamala ma'am for basically, inviting me and considering my participation on this panel. It's really wonderful to be a part of emerging research, especially at a time when it becomes very needy and crucial at this inflection point. So I hand over the mic to my colleague here, and wishing you a great day.
Thank you, Satyogi sir, for sharing such an insightful perspective. Your thought have added great depth to today's discussion, and we deeply appreciate the time, effort, and expertise you have contributed to this session. Now, without further delay, let us proceed with our first participant. I would like to call Ajay Krishna from School of Law, Chennai, along with his co-participant Sayana.
Okay, for the participants, before moving ahead with the technical session, since I joined bit late, I'd like to give my vote of thanks to Satyoki ji for coming up and giving this so wonderful address to the participants with explaining the intricacies which the SCP is having, and in such short notice he has provided and came his address to this conference. We are really grateful, and for the participants there are few instruction to be noted. Each presentation would be for 8 minutes, that is 6 minutes is for presentation and 2 minutes should be consolidatedly taken for question and answers if any questions are to be asked. Overall, like, try to wrap your presentation by 8 minutes. Thank you. We can proceed with the first participants.
Yes. Good morning, all.
Good morning, all. Good morning, all. Good morning, all. Good morning, all.
Ajay, I guess you'll have to leave the Google Meet. That's why it is
Hello.
echoing. Yeah, could you please leave the Google Meet link? It might be echoing because of that.
Yes, am I audible right now?
Yes, you are perfectly audible now.
Okay. And are you able to see my screen? Like I have shared it from a different one.
No, we can't.
Okay. Mhm. Because I have shared the screen from a different mail ID. That screen.
Mr. Ajay, you can just start like sharing your screen from the presentation itself.
So now, is it visible now?
Yeah, it's loading. Yeah, you can start.
Okay. Thank you all. So a very good morning to one and all. Today, me along with my co-author, Ms. Sayana MS, we are presenting our research paper on the topic resolving patent licensing impasses, that is, towards an autonomous fair access system in global technology standards. So this paper, it is basically aimed to explore the challenges which are being highlighted in patent licensing spectrum. Also in particularly emerging economies like India. And as we are in an era of digital disruption, especially after the post pandemic, we feel like the subject deserves more attention in this period. And we also highlights upon by drawing different case studies and technological proposals, as well as we highlight power imbalances in the context of licensing. Also, we suggest a decentralized and adaptive framework through this paper. So let's move on to the paper. Like the first part will be with regard, 1 minute, let me share my screen. Okay. So the first one will be with regard to navigating patent licensing challenges. In that, we are addressing escalating complexities in the patent licensing in the era of technological transformation, and that in that we are suggesting upon as global technological ecosystem has evolved, the traditional licensing framework is to be deferred, and we understand through our research that the FRAND, that is the fair, reasonable and non-discriminatory system, that is lacking its power. We should transfer it into a new and evolving method. Like it should not be particularly governed by the FRAND system. And there is also an increasingly inadequate system
Mr.
in
Ajay,
addressing the
your slides
systemic
are
power
not moving.
imbalances and
Your slides are
ensuring
not
the
moving.
equitable access to innovation. The challenges are pronounced in emerging economies due to exorbitant royalty demand, the market dominance by the patent holders hindering local innovations, and also by perpetuating technological demands. This highlights cases of Qualcomm and Ericsson with the Indian firms, revealing limitations of conventional bilateral negotiations as well as the role of exacerbated global disruptions like the pandemics. So, in this head, we propose a transformative shift towards autonomous AI driven decentralized systems, as well as we intend to leverage machine learning to address the challenge. Also, the blockchain inspired validation techniques can be used alongside use of behavioral economies to deal with the challenge posed. So, in this head, we would like to suggest for the creation of a transparent, adaptive, and equitable licensing framework rather than the FRAND framework to analyze this concept. With focus on Indian experiences and global case studies, we advocate for self-governing patent ecosystem, which is prioritizing technological merit and accessibility, and also aims to foster inclusive innovation in fields like 5G, AI, and Internet of Things. So the major highlight that we would like to propose is a shift from the FRAND system to a system of transparent, adaptive, and equitable licensing framework. The second one that we would like to highlight is with regard to the role of AI and blockchain technologies in creating equitable framework, which we analyze through the Qualcomm versus Indian smartphone manufacturing, as well as Ericsson versus Indian telecom operators, and Ericsson versus Intex technologies. Now, shifting
Mr.
paradigm
Ajay, your
from
slides are not
traditional.
moving. Mr. Ajay, your
Hello.
slides are not moving. Your slides are not moving. Just scroll in, like, no need to view it. Just scroll from the main area.
So from my side, it is showing that the screen is being shared.
Screen is shared, but your slides are not moving. You can just scroll down the slides. Do not just view it. It may be like not complete screen is visible.
No, I am changing the slides, but is it not changing?
No, no, it's not changing.
Okay.
You can go back and scroll down. Just scroll in the main area of the slide section.
So is it visible now?
It's not even showing in the stage. Okay, try to change it. Yes, yes, you can
Okay,
continue.
okay.
Yeah.
Perfect. Okay. Second thing that we would like to highlight is with regard to a shifting paradigm, that is from traditional FRAND to the autonomous equity driven models. In that, we would like to suggest for the FRAND's subjectivity and susceptibility to manipulation, and we would propose a AI driven model for objective data based equity. Equity is to be taken into consideration in this present sphere. So that we would like to raise points like a dynamic term adjustment via machine learning, as well as a decentralized network for transparency. Also, a self-regulating AI to prevent any sort of conflict which is being arising in the stream. Also, integrating behavioral economics and through introducing a scalability for emerging technologies like AI and quantum computing, we would be able to deal all those lacunae which comes within this sphere. The Ericsson versus Micromax case is a very good example where we see a shifting paradigm from the traditional FRAND methods to the autonomous equity driven models. The third one that we would like to address is the post-pandemic realities. And in this, we would like to reveal the escalation pattern in healthcare as well as remote work sites and digital sectors. In this, we would like to point out the supply chain disruption, worsening equity, the stakeholder divergencies, the increased refusals and excessive demands, cultural or regulatory differences, and rise of new SEPs in video conferencing as well as digital health. Also, the Indian ventilator manufacturing dispute case and the 5G delays exemplifies this concept. This we can see through the case like the Qualcomm versus smartphone manufacturers and the generic medicine manufacturers versus international pharma, in which the Indian Supreme Court highlighted the public interest approach rather than going for economic benefits. Then the fourth one is algorithmic mediation, leveraging AI and behavioral economics for fair negotiation. So in that we would like to highlight reduced bias in this field. Also propose machine learning to analyze precedents for optimal outcome. Also, we would like to suggest predictive conflict identification embedded with AI and real-time market analysis, a transparency of trust, cultural sensitivity, and the use of game theory. Next, going into the decentralized validation network, we would like to focus on blockchain-inspired network for transparent and peer-to-peer validation. Then the fifth one, dynamic licensing equilibrium. We would like to come up with an advocation for adaptive system for ongoing adjustments like the AI monitoring for equilibrium, the predicting tactics which are being used for predictive analytics and such related things, and going for a feedback loop, behavioral integration, sustainability metrics, and cross-platform compatibility. Then going into prototypic future for machine learning framework, we would like to focus on detailed prototype using neural network by ensembling methods for recommendations, behavioral simulation, integrate with databases, customization, and for quantum computing. And when we look into the legal sphere, which deals with this concept, even though we are pricing upon India's initiative of developing a patent regime, and that patent regime which is concentrating more on the new technologies through amendments, but we propose some gaps also. We suggest that there are some lacunae in this field. So these lacunae involve, one is it is over subjectivity to FRAND. The second one is the power imbalances in terms of multilateral and bilateral negotiations. And the third one is inadequacy in immediate response to the systems or to the mishaps which are coming up like the pandemics. Fourth one is a lack of stability and adaptability. And the fifth one is algorithmic bias and the oversight gaps. So charting a path from flawed traditional licensing traditional licensing to AI-powered, equitable-driven system using India's experience and the global blueprint. So, by embracing autonomous framework, we can democratize innovation as well as bridge all these gaps. So, to conclude, we should keep in mind that we should empower innovation and not domination. The autonomous licensing are for a fair future. And for that, we should visit upon the use of AIs and other machine learning technologies, which are in the forefront of the technological innovation in the current sphere, rather than we more rather than we more concentrating upon the FRAND developed concepts. Thank you.
We would like to now proceed with the Q&A session.
I think I can ask a question. Thanks a lot for your presentation. Can you hear me?
Yes.
Yeah. Hi. My video feed has gone off. I'm not sure why that is. But so it's a nice presentation and a good way of looking at how licensing mechanisms can be basically enforced with AI and machine learning. The question really is this: that if you were to look at the approach of the Indian courts, especially the Delhi High Courts, they've taken, and most courts across the world have taken the approach that FRAND is not uh, something which is a use case to use case sort of a determination. So there cannot be a generic analysis of FRAND when it comes to, let's say, implementation of a technology onto a use case. Rather, a use case has to be looked at and then arrive at what could be like a determination of FRAND. Uh, does the mechanism that your research paper talks about take into consideration that there are probably infinite possibilities when it comes to adoption of cellular technologies?
Of
And
course, sir. Of course.
yeah. So how does it propose to mitigate the differentiation when it comes to use cases?
Sir, what we identified through our research is that when we are more concentrating upon the FRAND regulations, we are not that much being looking into the novel needs of the domestic. The main intention of we prefer that the main intention of the patent protection is to stimulate the domestic market rather than more focusing upon the global sphere. So if we are concentrating more upon the global sphere through this FRAND enabled things, our domestic markets would come down. So that was the observation by the Delhi High Court also in the Qualcomm case. So if the thing that we have proposed, that is for a transparent, adaptive, and equitable mode of licensing framework rather than FRAND, we would be able to substantiate more into this concept and substantiate more into the local innovations and give them more promotion, and by that way we would get a more access into the global market to our domestic products. And for that, rather than FRAND, this concept of transparent, adaptive, and equitable licensing framework will help in that manner. That is what our research suggests, because we have analyzed over 25 recent developments which came after the pandemic. Post pandemic, we have looked into more than 25 things, and all have suggested that rather than this FRAND framework, if we are going for this transparent, adaptive, and equitable licensing framework, that would be more helpful.
Thanks. Yeah. Thanks.
Okay. Thank you.
My presentation. I would now like to call Dr. Priyanka Bhaumik from Tripura Law College for her presentation.
Hi. Uh, Today, first of all, good morning, everyone. Today, I want to present on traditional knowledge. First of all, I want to share my screen with PPT. Yes, my title is Recognition of Traditional Knowledge under Umbrella of IPR. Here I want to say that my I mean topic is recognition of traditional knowledge is not recognized under IPR. It is known to everyone, but traditional knowledge can be recognized under umbrella of IPR if we take some measures. Like my objective of the study was to explore traditional knowledge first. What is traditional knowledge? Need of traditional knowledge, ways of recognizing traditional knowledge, how traditional knowledge can be recognized under IPR. Then re-examine the way forward for benefit sharing process. Benefit sharing process is the most vital part of traditional knowledge, innovation based innovation. Now, what is traditional knowledge? Traditional knowledge is a kind of knowledge which passed by one generation to another generation for preserving their lifestyle in hostile environment. Most of the indigenous people in the whole world are living in sometimes their environment is getting hostile, and by taking resort to traditional knowledge, which is their own knowledge, own community knowledge, they can preserve their lifestyle, they can preserve their own identity. This is the main thing of traditional knowledge. Now how, if any researcher is taking the knowledge and making any innovation, then what is the process to give recognition to those communities who are holding those traditional knowledge? Need of traditional knowledge is the next slide. Need of traditional knowledge is already I have said that it, because they are living in the remote hostile environment, so they need their own knowledge to preserve their life, and accordingly they can proceed. Now, benefit sharing process. First of all, the if any innovator taking knowledge from traditional people and then making any innovation, how can it benefit will be shared by those innovators towards those communities. Now those community can in my study I saw that those community can take benefits from government side or private side, through banks, through establishing banks, especially for those communities, by taking loans, stipend, and that can be distributed from the money gained from the TK based innovations. Whatever the innovator has gained by this knowledge in innovation, those money can be distributed through banks, through loans, through stipend towards the communities. It is the main part of my study. Now the main thing can be done like that. Whatever the traditional knowledge are there in TKDL in India, there are most of the people are in living in whole world are in with traditional knowledge. They can be digitalized information, there can be digital and information about them, and then it can be distributed like whole countries can come together, and through convention, through conference, through convention, through treaty, through agreement, they can come together and they can share their own countries traditional knowledge information with other country, and then they can make one umbrella. And within this umbrella, all the communities living in the whole world, they come under within one platform, and then it can be legalized and in administrative way and in the legal way. Like communities, traditional knowledge is the vital tool for the survival of indigenous communities living in various parts of the world. TK should be protected and preserved for the communities, because it is the for long drawn conclusion maybe, but most of the people in the whole world, those communities are urging for their own right to be established, to be recognized legally and administrative way. This is my concluding remark. Thank you all.
Thank
I
you,
would
Dr.
now like
Priyanka.
to invite Mr. Satyoki for Q&A session.
Yeah. Thank you, Dr. Priyanka, for your presentation. Specifically, talking of the traditional knowledge, the only issue which we face is on recording the traditional knowledge and how to calculate at from what time was the origin of the knowledge and to what community the knowledge belongs. So these are the challenges when it talks about the TK. But Indian government already, we are the government is taking initiative. We are having the traditional knowledge national library developing. and it's going to be the world's first digital repository for traditional knowledge. So, like, how you feel that what are the solutions when we look through that, how to identify who are the stakeholders of those traditional knowledge, because we also saw there are various patent cases in US, specifically turmeric patent case, neem patent case. So in those cases the only issue was like,
Hi there. Did you just say Q&A session?
yes, Satyoji, yeah, right now Q&A session is going on.
Actually, I want to
Hello.
yes, whatever you want to ask me, I just got it. Actually, various countries should have their information regarding all the communities, and those information should be shared by countries respectively with each other. Then only it can get a one I mean whole through umbrella of digitalized information. Then communities can be identified, stakeholders can be identified in the whole world basis, because whatever the knowledge is in India is the same knowledge can be in America also. So if those communities who are having the same knowledge, they come under the same umbrella, same digitalized information platform, then it can be easily identified and benefit sharing can be done accordingly. It is my opinion.
All right, thank you, Dr. Priyanka.
Thank you very much.
Manik, we can move with the next participant.
Yes, sir. Now I would like to call Miss Neha Bhorane from Faculty of Law, GLS University.
Hello, I hope I'm audible and visible to everybody. I'll just connect my PPT. Just 1 second. Just a second. I think there's some. Is it visible?
No,
Okay, just a second. Just a
no
second.
worries.
I'll just share the screen. Okay, is it visible now?
Yes, it is visible.
Okay. Yeah, good morning to all the delegates and the panelists. It's an honor to present on recalibrating FRAND licensing, balancing market fairness and innovation in the global SEP landscape. Now, in our increasingly interconnected digital economy, SEPs is interconnected to all the technologies that we use daily, from 5G networks to IoT devices, from AI protocols to advanced communication infrastructure. To ensure these indispensable technologies remain accessible to everybody, we rely on FRAND licensing principle, which is fair, reasonable, and non-discriminatory. Now, FRAND aims to strike a balance, rewarding the innovators who invest heavily in R&D while ensuring fair market access for implementers, including those small enterprises and the developing economies which need them the most. So, coming to the theoretical framework, SEPs differ from other patents because you cannot comply with an industry standard without using them. That creates risk of patent holdup, demanding excessive royalties from the people who actually own the patents, or refusal to license, which can block market entry altogether. So, because we know that the FRAND goal is actually focused on fairness, reasonability, and non-discrimination, but when you look globally, there's no common definition if we talk about whether what's fair or what's reasonable. Different courts set different royalty benchmarks, creating uncertainty, and there are lot of negotiation deadlocks and ultimately barriers to equitable participation. So when we look, like I have taken 2 3 different countries where the FRAND technology is actually used the most. One of them is USA. Now, friend technology is actually viewed here as a contractual obligation. So it's person to person. It's not applicable to the entire country who are involved in the SAP's technology. So there's a case of Microsoft versus Motorola. The court applied a modified framework to determine royalties, focusing on the value of technology within the standard. They did not created the bargaining position here. So US courts are generally reluctant to grant injunctions unless there is a clear evidence of bad faith from either of the parties or the licensee. However, the policy debate remains unsettled, and they have not clearly defined that even in the
Miss Neha,
contractual
your
approach.
slides are not moving. Your slides are not moving.
Is it moving now?
No, it's not.
Okay, just a second. Let me try something else. Just a second. Okay. Okay, is it moving now?
Yes, it is.
Okay, okay. I'm so sorry for the interference in between. Okay, so moving to slide 4, I have taken the European Union. Competition law plays a very crucial role here. So I've taken a case here, the Huawei versus ZTE case. It created a step-by-step good faith negotiation protocol. So if either party strays from it, then they risk losing the entire legal protection that they get with the license that they purchase to use the SAPs. If we look at China, courts have become assertive, even setting global royalty rates in cases like UI versus Conversant. They also have anti-suit injunctions to block parallel foreign litigations going on in other countries. But when we look at India, if we apply it in India, we are still in the early stages of SAP jurisprudence. Cases like Ericsson versus Xiaomi have exposed gaps. We have no statutory SAP provisions, inconsistent interim relief, and there's a lot of tension when we have with Competition Commission of India and how the developing markets in the country are requiring SAPs currently. So if I look at the key challenges, my analysis actually show these three that I want to discuss because of lack of time. The first is that divergent royalty methodologies. Like if you look at the top-down approach in UK or the incremental value in US, the royalty outcomes is very different because of no standard in royalties. Then large multinational SAP holders, they dominate a lot of the market, and especially when we look at the global south, there's a lack of resources because nobody knows how to negotiate with these big whales or big sharks rather, if we call it. And confidential agreements and incomplete patent declarations, makes very hard for implementation to know what exactly is reasonable in the SAP policies. So these factors, they actually create a lot of problem when you look at why currently SAP licensing is creating problems around the world. So I propose four basically pillars. This may or may not be idealistic on my part, but I say that publicly accessible records of FRAND commitment, royalty ranges, and negotiation timelines is very important. So that is voluntary licensing registries. Then we have royalty benchmarking panels. We have expert bodies like WIPO or WTO who can issue a benchmark for royalty licensing so that someone is not taking too much and someone is not getting too little. SAP specific arbitration panels for dispute resolution and active participation in a standard setting body. So we need someone who can actually make recalibrate the entire SAP technology currently, which is missing around the world. So recalibrating FRAND has a lot of potential for all of us. It can enable technology transfer and localization very easily. Then it can make digital infrastructure affordable for small scale enterprises or the developing countries, and it would create a more innovation ecosystem if the people who are making them is also getting money, and the people who want them is actually getting it at a reasonable price to create something more new. At least that's what I feel. So to conclude, FRAND was
Miss
conceived.
Neha,
Yes.
yeah, we would now like to proceed with the Q&A due to paucity
Can
of
I
time.
just conclude? I just need like 30 seconds if it's
Yeah, yeah,
possible.
sure, sure.
Yeah. FRAND was conceived as a bridge between innovation and access, but today the bridge is riddled with gaps and definitions. So the way forward is global corporation to come up with an idea to recalibrate FRAND so that it is accessible to everybody. Thank you so much for listening to me, and I'll take the questions if there are any.
Thank you for your presentation, Ms. Neha. There is no question from my side.
Okay, so
I think I have an observation. Can you hear me?
yes, sir, I can.
All right, all right. I couldn't see your screen, so there seems to be some issue on my end, perhaps. But I was listening to you. So a couple of things here. While I do acknowledge that the licensing framework has certain issues in terms of, let's say, transparency issues, etc. Of course, because these rates are a matter of bilateral negotiations, it will always be confidential.
Yes.
The second, when it comes to issues on competition, of course, we do look at the matters of which have been determined in the US and EU. And if you look at the US, for instance, you had mentioned, or somebody had mentioned FTC versus Qualcomm. This was a 2000. This was 2012 or 2013 matter, after which there were no further investigations, right? And if you look at the European Commission's investigations, let's say Motorola and Samsung in 2014, these cases were never appealed, right? The court really said that Motorola and Samsung did not kind of engage in any anti-competitive conduct. And then Huawei versus ZTE came by, the CJU, which is different from the European Commission. Of course, Huawei versus ZTE was again another investigation under Article 102, which is abuse of dominance. The European Commission considered this, that if the SEP holder goes to the court and says, I need an injunction for a FRAND committed SEP, that could be an abuse of dominant position unless the SEP holder can basically establish that the infringer is behaving behaving as an unwilling licensee. So the question of willingness came into being, and that question of willingness has been decided by Indian courts over and over and over again. The latest, being the interim determinations of the pro tem, etc., etc. So here we look at the approach of the Indian court vis-a-vis the courts in US and EU. Although I would just want to place a disclaimer here that the jurisdiction of the Competition Commission is under sub judice because the matter is at the Supreme Court. The determination by the division bench has been that the Patents Act is a complete act by itself. It acts as a lex specialis and basically has the authority for the Patent Office to investigate into any issues of discrimination, etc., etc. But that beside the point, we look at the approach of the Indian court. The Indian courts have taken an interim approach because of certain operational issues, such as, while we look at the UK court, etc., where a FRAND trial takes place, it's difficult to conduct a FRAND trial in India. That's number one. Number two, litigation timeframes are pretty long in India. So you could probably consider 6 to 7 years, etc., etc. In a time frame where, this is a good data point for you, that the average negotiation time frame for matters to precipitate into litigation is about 6 to 7 years.
Yeah.
An average litigation time frame, if you look at a decree, is probably around 7 to 10 years. This means to say that, before ending up with a decree, the patent is going to expire.
Yes.
Which means to say that any question on an injunction becomes infructuous. The court is only left with the other, not so good relief, which is called compensatory damages for usage, which has gone years and decades back, right? That is first question number one. In this sort of a context, the court has come into an interim measure, which is called pro tem. So if you look at the recent orders of Dolby versus Lava, or Philips versus OnePlus, or Nokia versus Oppo, etc., courts have basically said that, look, we want to adopt a middle path sort of an approach. A middle path means this, that, the Huawei versus ZT basically entail that if the matter goes into contentious proceedings, then the party who's implementing the solution has to basically place something which is called a security deposit. This was placed in Huawei versus ZT. And the party, or rather the asserter or the SEP holder, is not precluded from asking for an injunction in the court. What the Indian courts did was this. The Indian court said that, look, we want to adopt a middle path sort of an approach. We know that determination of rates, etc., is a bilateral exercise, which kind of involves the court to look at multiple things. Now, this top-down approach has been rejected by courts across the US as well. Microsoft versus Motorola was a good approach, but this approach never kind of stands ground when you come to determination of multiple use cases, because the top-down approach fails. Right. Which means that the courts are left with something which is called the comparable licenses approach, which means that the courts will basically ask the party to place in agreements they have signed with substantially similar parties, or parties which are placed in similar positions, and then arrive at what could be like a FRAND determined rate. The Indian courts did was this. They said that, look, you've got the provisions under the procedure in India to basically place your license agreements under a confidentiality cover, either through setting up of a confidentiality club or placing those agreements under a seal cover, etc., etc. And injuncting a party from not conducting their business is going to be detrimental given the time frame of a litigation. True. So the middle part approach is this, that let the other party deposit a certain amount in the court. It doesn't go to the SEP holder. It stays with the court as long as the litigation subsists. So the SEP holder is basically assured of the fact that even if the other party goes into bankruptcy, which, by the way, a lot of parties have gone into. You mentioned Ericsson versus Xiaomi. There was Ericsson versus Eyeball. Eyeball went into bankruptcy. Ericsson versus Gioni. Gioni was sold overnight in a gamble in Macau by the party. So very interesting propositions have come into being. Videocon Dolby. Videocon went into bankruptcy, an Indian company itself. Yes. So the court said was this, that you basically spent years and years in research and development, and there has to be some sort of an assurance for you. So let the other party deposit a certain amount in terms of its past practices and future sales, and that amount can act as a security for you if the other party goes into liquidation or has a depreciated financial standing when it comes to their business in India. To the other party, the Indian court says is this, that, look, we don't want to stop your business. You keep on doing your business. You just deposit a certain amount of money to the court. It works for both the parties. The moment there is a deposit of an interim or an interim deposit in the court basically says that let's move into an expedited trial. So all the arguments for interim injunction, etc., are basically replaced by an order for deposit of money. And this approach has worked. In terms of quantification, a lot of these matters have gone into settlement after deposit of pro tem orders. Right. So which is to say that the Indian courts have basically taken an approach which has led into a lot of settlement, global settlement, by the way, an approach which has not stopped either of the parties from conducting their business, while providing an assurance to the party who's developed the solution that even if the other party has depreciated liquidated holdings, you are basically assured of at least some amount of money which can go and cover your R&D costs. True. This comes about at a time when the Competition Commission of India's jurisdiction is currently determined at the Supreme Court. We don't know how the case is going to proceed. It is sub judice. But at the moment, the law stands as this, that the Patents Act itself is a complete act. And this kind of finds consistency in the European and the US approaches, to say that there has been no further investigation from 2012 in the US and no further investigations in the European Union after Samsung and Motorola. So, which is to say that Competition Commission perhaps has a limited standing when it comes to determination of, let's say, abuse of dominance, which is to say that an SEP holder is going to coerce a party into coming into higher licensing rates at the prospect of telling them that you probably might be injuncted. There are no injunction orders. It's basically replaced by deposit orders. And those deposit orders have also kind of found ground in India. Just a thought here.
Thank you so much, sir. Actually, there are a lot of points that might be considered again if a research paper is to be written on specifically on the enforcement settlements. So I really appreciate your points and I've noted down everything. Thank you so much, sir, for these pointers.
Absolutely.
Thank you, Mr. Satyogi, for such a valuable insights, and thank you, Ms. Neha, for your presentation. Now I would like to invite Dr. Renu uh, from Amity Law School, Mohali, for your presentation. Now I would like to invite Dr. Vaswa from IILM University for her presentation.
Am I audible?
You are audible, but you are not visible, Miss
Okay,
Vasava.
okay, just a second. Am I visible
Yes,
now?
Yes, you are
yes, you are
visible now.
visible.
Okay, so very good morning to the session chair, to the host of the session, and to all the dear participants. I am sharing the screen. Let me know when it is visible. Is my presentation, is my PPT visible?
No, Miss Vaswa, it's not visible.
Is my presentation visible?
No, it's not.
Is my presentation visible?
There can be technical issue from your end. You have to
Am I
like
audible?
reshare. Yeah, you are audible, but your presentation is not getting uploaded. You can share your screen. If screen
Okay,
share option is available.
just a second, just a second. Is my presentation visible?
Yeah, it's
Yes, it's
visible.
visible now.
Yeah.
Okay, okay. Thank you so
Just
much.
scroll down.
So,
Just scroll down and change your slides. Do not like give on a view mode because it's not slides are not movable in the view mode. Okay.
are they moving?
Yeah, it's moving. You can just show it scroll down. Yeah.
Okay, okay. Thank you so much. So the title of my presentation is Patent Grant Processes and Innovative Techniques, a comparative study between India and USA. So just with a brief introduction of the topic, patents come under the intellectual property rights as IPRs cover many other aspects also like copyright, trademarks, geographical indications, and many more. And in the era of digitalization, IPRs have gained a significant place in the legislative frameworks globally. And IPRs indeed play a vital role in the economic growth of the nation as well. So particularly when it comes to patent, it is they are as an innovation which is being patented, and the patent holder is given certain rights. They are given the exclusive rights to use his or her own invention. These rights allow the creator exclusive control over the use of their creation for a specific duration of time, fostering innovation and providing economic incentives. The Section 3 of Patents Act 1970 provides certain inventions which cannot be patented. And this section is a very wide sections like mere admixtures, the microorganisms, and many more things are there which cannot be patented under Section 3 of the Patents Act. Now let us talk about the process of granting the patent in India. First of all, any invention, if it needs to get patented, it must qualify the non test, that is novelty, uniqueness, and non obviousness. It should be a novel concept, it should be new, it should be capable of industrial application. Only then the invention will get patented. Another aspect is that non test provides the foundation for patent examination in many jurisdictions, including India, guaranteeing that only genuine, useful, and innovative ideas are granted patent protection, which is the need of the patent. The patent procedure begins with the invention disclosure, in which the inventor or applicant documents the invention in full technical details. And once the non-test is satisfied, then the patent holder, not the patent holder exactly, but the inventor can proceed with his or her innovation. Another step is the application which is being filed in the patent office, and then the publication of application after 18 months from the priority date or the filing date, whichever is earlier. This publication makes the details of the application publicly accessible so that any person, if he or if any third party has any objection regarding the invention, can raise such objections. And then it is known as pre-grant opposition. And then what we can say is that the patent procedure in India is regarded as a complex procedure, because as per section 3D, many various kinds of inventions do not come under the ambit of patent grant. So another thing is that IPRs are people are only aware of IPRs who are lawyers or who are an academicians or who have specifically dealing with IPRs only. But common people, they do not know about intellectual property rights, specifically patents. And patents are very important for us because it directly contributes towards the development of the nation. So what in my opinion, in my research paper, I have done a comparative study between the grant of patents in India and USA. So these are some of the differences, in short, which I have added in my presentation. But in my research paper, there are many other differences also which I have pointed out. So in US, it allows the patents for software, business methods, and even genetically modified organisms. And in India, the exclusion is made to certain categories like software, business methods, and natural substances. Obviously, they are not patentable. Another thing is that US patent law is more flexible in allowing amendments and continuation applications, whereas in India, Indian patent law, we can say it is not flexible. It is followed in a rigid sense, with a limited scope for modifying the application once they are filed. Another thing is that there is very less awareness in India. Like as an academician, we often conduct many awareness programs or awareness campaigns. We have a center of IPR to provide awareness to the common people also, that if they create anything, if they invent anything, then that particular invention can be patentable. But there is a restriction which is imposed under section 3 of Indian Patents Act. Another difference is that faster and more streamlined process in US, but India doesn't have more streamlined process. And then government and private sector setup. US offers tax incentives, grants, and venture capital support for patent heavy industries, whereas India is still catching up with initiatives like Startup India and Make in India projects. But the ecosystem is still evolving in India. Lastly, in conclusion and suggestions, what I have made in my research are important for development of the nation and for the advancement of the nation. And in the present scenario of technological development, it is very important for each and every person to understand what IPR says and what patent is, so that more and more inventions can be created and more we can move towards the developed India. And what the suggestions can be inculcated is to narrow the aspect of section 3 of Indian Patents Act, so that more and more inventions can be done and more patents can be granted to India. This was all for very brief about the topic. Thank you so much, and I am open for questions.
Okay, thank
Am I
you,
audible?
Miss.
Okay.
Yeah, you are audible. Thank you, Miss
Okay.
Vasara, for your presentation. Only one question I have. Specifically, we see nowadays various AI models or AI tools are getting implemented as a pilot project in some of the IPOs, like Intellectual Property Office. Recently, we saw that even IP Australia, Intellectual Property Office of Australia, has like taken a pilot based mechanism which is known as the predictive patent examination model, which would be piloting in IP Australia right now. Can India take such can India Intellectual Property Office can take those models in coming future, like what according to your opinion?
Yes, definitely, because India needs to develop many things right now, and India undoubtedly it has a comprehensive legislative framework dealing with IPRs, but India can move forward to do such things also, which other nations are following. But for this, we need to spread the awareness regarding IPRs to the individuals.
All right.
Any other questions, sir?
If I may come in, hi. Can you hear me?
Yes, sir.
Hi. So the trademark office in India, they have basically included a AI powered search tool, which is available for the public, and certain similar initiatives are underway as we speak for doing patent searches. As it stands, uh, the database has not been very user friendly, if I may put it that way. It's been subject to a lot of uh, server maintenances and all of that, which makes it a little inconvenient at times. But that said, a lot of process is underway, especially because of the fact that the Indian Patent Office has become something which is called the IP5. What IP5 means is the 5 top filers in the world. And given that we've seen more than 100,000 patent applications being granted, not filed. So the filing numbers kind of exceed 100,000 patents being granted. I think a lot of that process, is needed and probably would come much sooner than we expect. That also said, it's important to note that the Indian Patent Office is currently one of the few government agencies which are autonomous, because of the fact that the official fees per se, which have been, because a lot of those filings are done by entities which are other than natural persons. So they go ahead and they file the full amount of official fees, etc., etc. Now the startups have come into being. This is an observation that I thought might make some sense when we talk about the recent initiatives, etc. In terms of awareness, in 2016, India had its national IPR policy. And within the aegis of the national IPR policy was an institution which was set, which is called CPAM, Center for Intellectual Property and Management is what I recall was the acronym. But this is, so the CPAM, the role of CPAM was to kind of do all these, the policy. If you've seen the policy goes on to say a lot of things about the powers exercised by CPAM, the resourcing capabilities, what's it going to do, what's it not going to do, etc., etc. But I think, given the fact that India is moving towards a high-tech sort of a domain, and it's probably going to become, the breeding ground for APIs, which is active pharmaceutical ingredients, which is to say that this, while it was China and Germany who were building APIs, it's going to be India in the next 5 years from now, where a lot of synthesis of APIs are going to be done, if not done already. There is a lot of need for CPAM to be resourced with adequate professionals and personals who are not only skilled in the area of patent law and IP law, for that matter, but also in the area of technical expertise. And that needs to kind of percolate into academic institutions as well, technical and social, legal, law universities, etc., for basically substantiating the sort of efforts which is needed. And perhaps, there are certain institutions who are also playing a role in creating awareness from the school level itself, which is to say that, the IP office, they started something which is called IP Nani, a comic cartoon, which was created towards understanding the basics of patents, trademarks, copyrights, industrial designs, etc., etc., through very funny, or rather relatable comic content. So all that content is available on YouTube. It became pretty popular, but I think a lot more initiatives are required, and that can only come from the aegis of national IPR policy, is what I think. So I think there is a need to revamp, given that we've already seen 9 years of the national IPR policy being implemented. Number two, IPR has become a facet which is not only essential to the ministry who's governing national IPR, which is DPIIT, but also into other government institutions like telecom. And a great example of it is the National Telecom Policy of 2025. It talks a lot about patents and SEPs and all of that. I'm placing this because this is an SEP conference. So, but the idea really is that, multiple government, offices are looking into IPR. There is the Make in India policy, or the public procurement rules, PPP, which kind of mandates that an IPR has to be housed within an Indian entity for an Indian entity to become eligible to participate in government contracts, etc. And the fourth is the need for CPAM, currently under the aegis of national IPR policy, to be resourced adequately. So a couple of observations for you. Thank you.
Thank you so much for such valuable suggestions, sir. I will definitely include it in my research paper. And thank you so much for enlightening me. Thank you so much, sir.
Thank you.
Thank you.
Thank you, Ms. Vaswa, for your presentation. Before we move ahead with the session, I would like to take a moment to express our sincere gratitude to Mr. Satyogi for joining us today and sharing his valuable insights on the nuanced and evolving landscape of SEPs. So your expertise and perspective have greatly enriched our discussion and provided us with thought-provoking ideas to reflect upon. We truly appreciate you taking the time out of your busy schedule to be with us, even if only for part of the session. Sir, on behalf of the organizers and all participants, thank you once again for your presence and contribution. We wish you the very best in your ongoing work and hope to welcome you again in future editions of this conference.
Thank you. Thanks a lot for having me. It's a pleasure to be here, and wishing all of you a great session.
Thank you, sir.
Thank you. Bye-bye.
Now, I would like to invite Dr. Reenu Chauhan from Amity Law School.
Manik, Dr. Rinu might have some issue,
Yes, sir.
because
I'll call the next person.
yes.
Now, I'd like to invite Aditi Bhardwaj from HSRC.
Miss Aditi, you are not audible.
Hello, am I audible now?
Yes. Kindly present your screen.
Hello. Okay. Good morning, everyone. This is Aditi Bhardwaj, and I will be presenting my paper today, and it's an honor to be here. I will be presenting my screen in a minute. Please bear with me. Uh, while that loads, let me just give you an introduction of the topic. Uh, I will be sharing the insights of my paper, The Disappearing Consumer, Rethinking SEP Enforcement and FRAND through a user-friendly centric way. So basically, what the main point of the paper is to change the lens and think about FRAND not through a corporate landscape, but through a user-friendly, consumer-centric lens. This paper is for innovation, this paper is for consumers, and this paper is for public access.
Miss
The
Aditi, your
agenda,
screen is visible. Your screen is visible.
oh,
Please share your paper.
okay, I hope it's visible now. Uh, so the agenda for today is I will give you a brief introduction. I will discuss the problem. I will give a comparative analysis, and then we will move on to recommendations and conclusions. So, SEP or essential patents is a licensing designed to ensure balance, rewarding
Miss Aditi, your
innovation while
paper is
guaranteeing.
not visible. Your paper is not visible. It is the screen of the StreamYard is visible.
Okay, sorry, apologies. Let me just share the entire screen so that we can all see. Right. I hope it's visible now.
Yeah, it's visible. Go ahead.
Thank you so much. Thank you so much for bearing with me. So basically, SEP and FRAND are designed for a universal application for essential technologies. So what happens is that when someone designs something that is essential for something else, for A design something for B, then someone can grant them and send essential practices and a FRAND. So basically, that goes through the FRAND policy. This is for universal access for essential technologies, but in realities, it is actually dominated by big corporations, while consumer welfare and public interest are barely considered. We will see how when we discuss some of the cases that come. My comparative analysis of US, UK, and India shows this as a systematic problem. So basically, the problem is that there is no consumer centric regulation. Is intended to ensure affordability, interoperability, but broad market participation. But in reality, it's an opaque licensing practice with a lack of brand definition itself. There's a corporate hijacking of SEP and an exclusion of small enterprises, civil societies, and obviously consumers. This happens because there is no universal definition of fraud. There is an inconsistent enforcement. This becomes a special problem when it comes to an international company and there is room for discrimination. There is obviously a secrecy in licensing, and that I understand that the big corporations obviously want to save their own trade secrets, and therefore they have a confidential wall built in. That is how they secure themselves. We will talk about it more in the recommendations, but it is a problem that affects everyone and causes anti competitive behavior. There are regulatory blind spots, and there is a democratic deficit where the policy is shaped by not consumers and public oversight, but actually corporate negotiation. The comparative analysis basically is of three nations: US, UK, and India. In US, in FTC versus Poland, there it's a big case that discusses so many things, but there is no consumer harm that was discussed, which is what this paper is trying to prove. That even in these landmark cases of not just United States, UK, or India, consumer-centric lens is missing when it talks about FLAND or SEP. In UK, Unwired Planet versus Hawaii, it clarifies global brand obligation but ignores affordability, SME access, and consumer impact. Patent holder rights are prioritized over public welfare. In India, there is no formal brand legal framework. And even when in the landmark Ericsson case, we talk about so many royalties in the opaque procedure that a government body has to look through. There is no disclosure requirements that are talked about, and there is no discrimination which is talked about. The judiciary is obviously a stalled enforcement. The judiciary in India works very slowly, and this actually causes some patents to even lose the right in some point. This can also affect the patent holders, but it can, in the long run, affect the consumers who need it. This has to be changed, not just because it is the right thing to do morally, but also because in the Atmanirbhar Bharat scheme and in the Make in India policy, this is what India is trying to do. So what happens to the stakeholders? What is the impact? So there are three major stakeholders that are talked about in the paper: consumers, small and medium enterprises, and the civil society itself. The consumers have to go through extra costs, reduced innovations, and delayed access because of the FRAND licensing process. The SMEs are locked out of the market due to high fees, legal uncertainty, and lack of transparency. The civil society is excluded from negotiations, and there is a standard setting procedure which is not actually talked about. Let's go through the recommendations. What can we do to solve it? So basically, a clear enforceable recommendation should be given of the FRAND definition, in which includes consumer welfare, a mandatory transparency in licensing agreements, which is I was talking about before. Mandatory transparency should have some basic points that have to be transparent to all the consumer and for public interest. And they should be in a language that is understandable by the enforceable agencies and by the consumers that are being affected as well. The competition law enforcement should prioritize affordability and equitable access. I know that competition law and IPR stand against each other, but the problem here in lies that they have to work together. IPR cannot always be an exception to competition law. They have to work together so that they can create an affordable and equitable access. Without systematic reform, brand risks become a legal myth that protects monopolies instead of prioritizing innovation. Reclaiming SEP and FRAND in a framework for consumers is essential for a global, inclusive digital economy. Thank you.
Okay, thank you, Miss Aditi. My only one question for you: how is the concept of consumer currently addressed, or what according to you it is addressed or ignored in the SCP enforcement framework for India?
India basically doesn't have a written policy. It follows very much of international norms. But when I talk about the international norm that it has followed, it is actually the best right now, which has, if we compare it to USA and UK, it actually talks about royalty stacking, it talks about opaque royalties, it talks about discriminatory practices to the consumers. India is actually doing better than USA and UK in that front. And it is a very judicially drawn concept. The judiciary is on its discretion to do it. But I think, in my personal opinion, it is working better than USA and UK.
Okay, like in the negotiation agreements which occurs between a SCP holder and the implementers, in most of the cases, the negotiation occurs between two company, the two making bodies. So, do you think that all those negotiations and agreements runs as per the jurisdictions or the jurisprudence of consumer protection ideology?
Sir, it is a very confidential process, which is what I have also said in my paper. So we cannot talk about it particularly because, again, it's not transparent. That is why I recommend that there should be some pointers which should be always transparent. It's a policy that it should be policy driven, and so these pointers have to be given. However, if I were to answer your question, I would say that it is not consumer driven because obviously the main point of companies is to make profits and corporations run on profits. If the agencies do not intervene, they will do the same and build a capitalist and monopolistic market. So I don't think they do.
Okay, all right. Thank you, Miss Aditi.
Thank you.
Uh,
Thank you.
Thank you, Miss Aditi. Now I'd like to call Dr. Reenu Chauhan from Amity Law School, Mohali.
You are not audible, Dr. Renu.
No, ma'am,
Kindly
you're not
unmute.
audible. Yes, you're
Yeah.
audible now.
No, you are not audible.
No.
Kindly unmute your and speak. Dr. Renu, please be fast. We are already running out of time. Your voice is not audible, madam.
No,
No,
you're
no.
not audible. Okay, now I'd like to invite Dr. Mr. Kuldeep from University of Technology, Jaipur.
Mr. Kuldeep,
Good, good morning,
your voice
everyone.
is yeah audible. You are not visible.
Oh, wait a minute, sir. There is a technical problem in my uh, web browser, actually. Uh, Wait a minute, sir. Am I visible now? Am I audible to everyone?
Yeah, yes, you're audible, but you're not visible.
Actually, sir, my webcam browser is missing, actually. I'm trying to install it since long, but it's not working at all.
Your camera is visible, but it's showing a blur image. Like you're actually not visible. It might be working, but you're not visible.
Wait a minute. Is it now visible?
No, it's not.
Shall we proceed without camera?
Kuldeep, you can proceed without camera and you can turn off your
Sure,
camera.
sure, sure,
Just
sir.
present your screen and present your
Oh,
paper.
okay, okay. Thank you so much. Thank you so much for giving me consideration. Now I'm sharing my screen, entire screen. I'll be sharing now. Do sir, is it visible?
Yeah, your screen is visible. StreamYard is showing right now.
Okay, okay, okay. Thank you so much, sir. So, uh, good morning, everyone. I'm Kuldeep, and I'm a research scholar at the School of Law,
Kuldeep, but your
University of
presentation
Technology.
is not visible. It's showing the same StreamYard page.
Is it visible now, sir?
No, no, no. You have to share the complete screen. Whole desktop you have to share.
Wait, is it now visible?
It's not.
Wait. Sir, is it visible now?
Kindly disconnect it and reshare your screen.
Stop sharing. Okay.
Yeah, and reshare with the whole screen permission.
Okay, sir.
Please be fast. We are
Present.
already running out of time.
Oh, sorry for that. Is it now visible, sir?
Yeah, it's visible. Yeah, go
Okay,
ahead.
okay. Thank
Start
you.
your
Thank
presentation.
you. Thank you so much, sir. Good morning, everyone. My name is Kuldeep, and I'm a research scholar at the School of Law, University of Technology, Jaipur. And it's a true privilege to be here today at this international conference on SEPs and patent innovation. My presentation will explore South Asian strategies on standard essential patents governance, offering regional focus and challenges in this rapidly evolving region. Uh, to to set the stage, here's a brief roadmap of our discussion today. We'll be delving into the intricate world of in- standard essential patents on SEPs, specifically within South Asia, focusing on India, Pakistan, Bangladesh, and Sri Lanka, and will examine how these nations manage SEP enforcement, the nuance of FRAND licensing, and the role of anti-suit injunction. A key part of our analysis will involve contrasting India's litigation-driven approach with the less developed frameworks in its neighbors. Ultimately, I'll propose concrete policy recommendations aimed at fostering a more predictable and harmonized SEP governance across the region. Let's begin by defining words the FRAND principles: fair, reasonable, and non discriminatory. This is a commitment made by SEP holders to license their essential patents under these terms. Its purpose is clear: to prevent anti competitive behavior and ensure that standardized technologies are widely accessible. It's a delicate balancing act, safeguarding the exclusive rights of patents holder while promoting the inclusive nature of technical standards. However, defining fair, reasonable, and non-discriminatory often leads to significant challenges, particularly in mitigating patent hold up by patentees and patent hold out by implementers. Coming to next. Globally, SEP governance presents a fragmented picture, largely resolved at the national level. Major economic players like the US, Europe, and China set crucial precedents, with their courts increasingly asserting jurisdiction to determine worldwide front royalty rates, as seen in recent cases from the US, UK, and even China. Interestingly, other regions like South Asia tend to favor negotiation and alternate dispute resolution mechanism over protected litigation. This global tapestry provides the backdrop against which South Asia's unique SEP landscape is unfolding. Moving ahead, now let's zoom into South Asia. This region is rapidly emerging as a significant technology hub, holding immense economic potential, yet it currently lacks a unified or coordinated approach to SCP governance. This fragmentation creates substantial hurdles for innovation, discourages foreign investment, and introduces market unpredictability while influenced by global trends. South Asian nations operate under divergent legislative traditions, leading to distinct national legal landscape that further complicate harmonized SEP management. Now, moving ahead, our core research question driving this analysis is how do South Asian countries manage the intricacies of SEP enforcement, friend licensing, and anti-suit injunctions, and what are the unique regional challenges and governmental solutions in reconciling innovations, competition, and access to standardized technologies. To answer this, we've employed a comparative legal and policy analysis driving from national patent law, competition legislation, and crucially notable judicial rulings. Our findings are augmented by specific cases studies illustrating the practical difficulties in conflict resolution and policy executions within the region. Coming towards the Indian perspective, India stands out as the litigious epicenter of SCP activities in South Asia. Despite its prominence, India notably lacks explicit SCP specific legislations. Disputes are primarily handled under the Indian Patent Act of 1970 and the Competition Act of 2002. Historically, the Competition Commission of India played a significant role, but recent Delhi High Court rulings have largely affirmed the supremacy of the Patent Act, consolidating SCP jurisprudence firmly within the judiciary. This shift has shaped India's unique and evolving SCP landscape. Uh, let's look at some pivotal Indian cases.
Mr.
That is,
Kuldeep, Mr.
yes,
Kuldeep,
sir.
you can proceed with the solutions.
Okay, 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 sir. So coming towards the findings, mm, here I have discussed some cases, some judicial cases, judicial precedents here. One of the persistent challenge in India, as globally, is stabilizing a fair FRAND royalty rate. A major point of contention is the royalty basis. The debate centers on whether royalties should be calculated on the net sale price of the ultimate downstream product like a smartphone or on the smallest C-level patent practicing unit, a component within the product. Indian courts have generally shown a preference for referencing the downstream product's worth and often rely on comparable license to determine appropriate rates. The Indian government, particularly Department for Promotion of Industry and Internal Trade, acknowledges the need for for a defined policy framework for SCPs. Beyond the courts, the uh, Huh. Beyond the courts, the Indian government, particularly through the Department of Promotion of Industry and Internal Trade, recognized the urgent need for a clear SCP policy framework. India aspires to play a prominent role in shaping global SCP licensing regime. This ambition is strategically aligned with within it Make in India initiative, fostering local manufacturing and innovations. Ultimately, robust SCP policies are seen as vital for India to achieve its broader goal of global technologies leadership. Uh, Moving beyond India, we find that other South Asian nations like Pakistan, Sri Lanka, and Nepal largely lack distinct SCP governance structure, while their patent laws, like Pakistan's Patent Ordinance and Sri Lanka's IPR Act of 2003, are TRIPS compliant. They generally lack explicit provisions for SEP or FRAND. Nepal's system in even more nascent with limited patents registration and virtually no policy discussions on NEP. Uh, Bangladesh also mirrors the lack of specific SCP governance seen in other South Asian nations, while regional bodies like SARC, the South Asian Association for Regional Cooperations, have aimed for greater collaboration. Am I audible, sir? Am
Yes,
I
you are
audible?
audible. Try to
Okay,
conclude within 1 minute.
sure, sir. Uh, Coming towards the conclusion and suggestions, in conclusion, SEP regulation in South Asia stands at a critical crossroad characterized by a profound divide between India's dynamic, albeit unstable landscape and its neighbors' underdeveloped structure. This fragmentation breeds legal ambiguity, poses risk for both innovators and implementers, and ultimately impedes the region's intri- integration into the global digital economy. Effective SAP governance is not just an option, it's a strategic imperative for harnessing regional innovations. The path forward requires India to shift from litigation towards explicit legislation, its neighbors to proactively enhance their capabilities, and SARC to seize the vital opportunity to foster genuine collaboration. Thank you for time and attention, sir. That's all from my end.
Okay. Mr. Kuldeep, Like you had mentioned shark in various part of your presentation. So
Yes, yes.
is there any existing regional dialogue on harmonizing SCP governance under shark?
So particularly about the dialogue, I'm not I'm not aware exactly, but I'll include it and I'll search it for and read further about it
All right.
to include
Yes.
it in my research. Sir.
All right. All right. Thank you.
Thank you. Thank you. Sir.
Thank you, Mr. Kuldeep. Now I
Thank you.
would
Thank you
like
so
to
much.
invite Advocate Rathul Dev from Markaz Law College.
Yes, Mr. Rathol, you can present your screen.
Sir, am I audible, sir?
Yes, you are audible and visible.
Okay, okay, fine, sir, fine. I will share.
After Advocate Rathul, we'll be proceeding with Dr. Rano. I think Advocate Rathul is having some issue. Okay. So, Manik, who is the next participant?
Yes, sir. So, now I would like to invite Nidhi Srivastav from Christ University.
Good morning, sir. Am I audible?
Yes, you are audible and visible. Please share your
Great.
screen.
Sure. I will. So is my PPT visible to you all?
Yes, Dr. Nidhi, it's visible.
Thank you, sir. Thank you so much. A very good morning to and warm greetings to all the ones present in the panel. It gives me immense pleasure to be presenting before you not just a topic of yet another intellectual property rights, but a topic of my passion and something that I have been researching on for quite a while. So the topic that I have chosen today and how is it relevant to the conference is what I will be talking about. So, the minute we think of an aeroplane or with respect to the law of an aeroplane, we only think about the air accidents that take place. Most of all, we may think about the insurance that will be guaranteed for that particular aeroplane, or maybe with respect to the parts of the aeroplane at large. But today, I will be narrowing it down and connecting it to patents. How exactly am I doing this? Is because we all would have seen that small TV screen which is there inside the aeroplane, which we also call a TV, but it is in fact called as in-flight entertainment system. This in-flight entertainment system is something which keeps the passenger entertained throughout the flight. It could be a long flight or a short flight. It has music, it has maps that it shows, and it has different kinds of games and puzzles that you can solve. So it keeps you entertained throughout the flight. Now, how exactly is it relevant to a conference which talks about standard essential patents? Is because this small screen that you can see on this particular shared screen as well is an in-flight entertainment device. So this device contains numerous kinds of components for which I will not be going through. I will only be concentrating on how exactly the patent for this in-flight entertainment system should be considered as a standard essential patent. So I'll just go to the next slide. Please let me know if it's not moving. All right. So now starting off with the concept of why exactly in-flight entertainment system should be considered as a standard essential patent. One, this particular research is going to connect two aspects. One is patenting as a concept, and two is in-flight entertainment, which is a aviation law concept. So intellectual property will be connected with aviation legality at large. Secondly, going into the patenting of in-flight entertainment system, the patent of in-flight will be described in detail. These are the folds in which I will be explaining this particular slide as a whole. And thirdly, I'll be explaining about the requirements of standard essential patent. And lastly, I'll be connecting it to how FRAND licensing, like how we have discussed numerous and wide as well, and how WIPO also discusses as to how FRAND licensing can be applied to in-flight entertainment device. Now, like I already explained an in-flight entertainment device, I would like to present some statistics before you. I hope it is visible. So this particular statistics tries and tells us only one thing. In-flight entertainment device, I have not put it on the slide, but I would like to explain the same, very much qualifies the nonce test. What is the nonce test? It is novelty, utility, non-obviousness, and of course statutory provisions in India and other countries do not consider statutory provisions. Now, how is it novel? Because in-flight entertainment system is not just one particular device. It has numerous parts within it. So the way India views it, you can see one on the slide in itself. So the second point here talks about India, and India clearly protects personalized in-flight entertainment. That means I enjoy my own in-flight entertainment by wearing my own earphones or whatever it is. That is what has been given as a patent. But US views it as a bigger system. So in US, they have given the patent to systematic kit, which covers in-flight entertainment as a whole. Now, lastly, Australia has also given it patent because it is a consolidated in-flight entertainment system, which is of course novel. Now, since novelty and innovation criteria is satisfied, you have to come down to utility. What is the utility? Like I told you, it is the entertainment in itself, which is the utility. Why is it not obvious to a person skilled in that particular profession is the reason why India, USA, and Australia have already recognized this as a patenting form. Now, why exactly should this particular in-flight entertainment be granted a standard essential patent? Now, a standard essential patent, as far as my knowledge concerns, and as far as WIPO has given the definition of, there are three important criteria. The first criteria with respect to standard essential patent or SEP is that safety norms has to be met. In-flight entertainment goes through a 3-tier system of safety check. And this can be found on WIPO website as well. And I'd be happy to include the link if need be. So safety criteria is satisfied. The second criteria of SEP is that it has to be a particular standard. In fact, TRIPS also mentions a minimum standard of patenting. And WIPO also mentions a minimum standard of patenting. And SEP is also mentioning a minimum standard of patenting. And it's slightly higher than that of regular patenting. Now, in-flight entertainment system is already novel, utility-based. It is not so obvious. And it definitely qualifies to be a particular standard. The last one that SEP requires is interoperability. So in-flight entertainment is not just for entertainment, right? It also includes the software, it includes the maps, it includes the music, it includes different kinds of copyrighted licensings that it has. So then there is different kinds of interoperability that is there. So the criteria of safety is met, the criteria of interoperability is met, and the criteria of particular standard is also met. Now that these three aspects are met till date, not just in India, but even in USA, even in Australia, or across the world, even in WIPO, nobody considers in-flight entertainment as a device which may qualify into an SEP. So through this research, I would like to put it forth that there is a requirement for this particular in-flight entertainment system to be qualified as a standard essential patent. I'd like to come to the next slide. These are the research questions that this research basically analyzes. Whether SEP can even be granted to an in-flight entertainment is the first question. The second one is with respect to what kind of catering can be done if standard essential patent is given or granted to the in-flight entertainment device. And the last one being FRAND licensing, that which I will be explaining further. Now, with respect to applicability, like I told you before I come to FRAND licensing, why should a patent of standard essential level, which is SEP, be granted to in-flight entertainment? Because one, commercialization will improve from 0 to 100. That is a major reason why SEP has to be granted to in-flight entertainment system. Second point is with respect to the IP framework. We all know WIPO is trying to promote the IP framework. And this IP framework will be absolutely strengthened if SEP status is granted to the in-flight entertainment system. It also interlinks aviation law and IPR, which brings up a new discipline altogether in the research. Now, thirdly, with respect to higher level of protection, Internationally, like I told you, Australia is already recognizing, US is recognizing, India is trying to recognize in-flight entertainment. So when globally we are at this scenario where in-flight entertainment has been recognized as a patentable invention, why not notch it up? Why not take it up to the standard of SEP, which is Standard Essential Patents, is this particular point. And the last 2 points I'd like to combine, and I would not like to keep it too large, I would like to keep it brief, where it clearly says that a higher level of benefit can be enjoyed when infringements are not there. Like we know, patent infringements are viewed seriously across different countries, not just in India. However, when a SEP is breached, for example, 4G LTE has been given a SEP status. Let's consider in-flight entertainment and 4G LTE. If 4G LTE has been infringed by someone in India, the level of punishment that the person receives will be way more than the level of punishment a person receives for infringing in-flight entertainment. This particular discrimination has to be taken off, and that's the reason when SEP status is granted, a little more level of protection will be granted to in-flight entertainment, is what this particular slides point out to. Moving on, please let me know if anything is not visible. Right. So now this is the point where I'd like to drain down to, which is fair, reasonable, and non-discriminatory licensing, known as FRAND licensing. Now, why should FRAND licensing even be applied to in-flight entertainment device? So if you can see the kind of in-flight entertainment devices we have, Air India offers a different kind of in-flight entertainment device. Let's consider a different plane of Lufthansa, and that offers a different kind of in-flight entertainment device. So there are many players. These players are split across competitive industries and across different agencies and nations as well. In order to notch it down, in order to bring it down to a consolidated bit, is why fair licensing is required. Once a fair norm or a minimum required criteria has been put up, in-flight entertainment can conform and in consonance be a part of that particular kind of fair licensing. So that's the reason fair licensing has to be applied to in-flight entertainment. Considering the second part, reasonable. Why is it reasonable? Because what is reasonable to Australia may not be reasonable to USA. What is reasonable to USA may not be reasonable to India. In order to make sure that there is a uniform criteria, uniform norm that exists across boundaries, across international spheres, if WIPO can bring it up and tell that there has to be a reasonable licensing criteria, in-flight entertainment should qualify this. And for it to qualify this, the reasonableness criteria has to be satisfied. The last bit of it being non-discriminatory. If at all you see the licenses which have been given by in-flight entertainment, there's in fact this one company called ASCAP, which is US-based company, and they almost own a monopoly with respect to in-flight entertainment devices. Now the concern is, if there is one company which is holding monopoly, what happens to the competition? Why are we talking about fair play? Why do we have to focus on everyone being equal, there being no dominant abuse? So all of this, in order to be eliminated and to make sure equal players get equal status in in-flight entertainment devices, there should be a non-discriminatory licensing. That is the reason fair, reasonable, and non-discriminatory licensing should be applied to an in-flight entertainment, and that is only possible when an SEP status has been granted to in-flight entertainment.
Ms. Nidhi, proceed to your conclusion.
Yes, sir. So the conclusions here is what this particular slide says. So once FRAND licensing has been given, commercialization is good enough, royalty terms are met, there is some amount of royalty which can be consolidated and made uniform so that there is no discrimination across, and that it's also reasonable, due to which SEP status, I'd like to conclude by telling only two things. So the only two things that I would like to tell is that an in-flight entertainment system should be granted an SEP, which is Standard Essential Patent status, and two, it has to be granted the FRAND licensing, and in-flight entertainment should be considered in utmost importance in aviation as well as intellectual property scenario, due to which SEP status definitely gives a good status to in-flight entertainment devices. With that, I'd like to conclude, and I'd be absolutely open to any questions that if exists. Thank you so much.
Okay. So Ms. Nidhi, what do you think that the international, like the satellite link protocol, specifically for in-flight internet considered,
correct,
like whatever the protocol are being used, are to be considered as a standard under the global SEP framework?
Correct.
Like, do you think so?
Sir, as of now, it is not considered. If you're talking about the recent dialogue that WIPO had, So WIPO also spoke about how exactly SEPs can be granted to a different kind of protection, right? So if you're talking about satellite in specific, it has not been granted in SEP status. Granted with respect to. Sir, am I audible?
Yes, your voice is scattering a bit.
Oh,
Like, can you repeat?
sorry, am I audible now?
Yes, you are audible.
Okay. So with respect to the satellite that you spoke, sir, satellite in itself, if granted an SCP status, will categorize differently for broadcasting devices. But with respect to in-flight entertainment, satellite alone getting an SCP status will not be sufficient, sir.
I'm
In my
not
opinion,
talking about satellite. I'm talking about
right,
satellite link protocols.
right. Does it have to be connected to SCP is what the question is?
Yeah, I'm talking about the satellite link protocols for
Yeah,
in-flight entertainment. Like, it can be the
yeah,
internet software from where the people are getting internet, the
correct,
sources of the media. So all
right.
those can be the standard as per the global SAP framework right now.
Definitely, sir, definitely. Because particular standard is met, there is safety protocol that exists. And lastly, with respect to the entire operationability, which is the interoperability link, that can be met with respect to the protocols that you're talking about. So there is absolutely no, let's say, impediment or wrong for it to be considered as a global SCP standard. The global SCP standard is good enough to be applicable, is what I feel, sir.
All right, Dr. Nidhi. Thank you.
Thank you so much, sir. Thank you. Have a good day.
Now I would like to invite Dr. Reenu Chauhan from Amity Law School for her presentation.
Am I audible, sir?
Yes, you are
Yes, you're
audible,
audible.
doctor.
Okay, very good morning to all of you, respected panel, distinguished speaker, my dear research fellows, and fellow faculties and esteemed participants. Yes,
Yes, go ahead, Dr. Renu. Your presentation is visible.
now I'm on the Streamline platform. ये StreamYard ही शो हो रहा है मुझे StreamYard शो हो रहा है ये.
Dr. Renu, you are in the StreamYard and your presentation is visible. Please go ahead with the presentation.
This is what I'm telling. So, see, very good morning to all of you. Respected. Now,
You
sir, am I audible and presentable now?
Yes. You can
So
present
shall
if
I
you are.
start, sir?
Yes, you can start.
Okay. Well, my name is Dr. Reenu Chauhan. I am from Amity School of Law, Punjab, and my primary area of research focuses on the intersection of international trade and intellectual property right, along with international organization, with special emphasis on its and their impact on Indian trade. So it is my privilege to be here at this prestigious international conference, which brings together leading minds to share ideas, foster collaboration across borders. In my presentation, I would like to address the topic, that is patentability of software under TRIPS, justification and implication for SEPs. See, as you know, Make in India Initiative 2014, it is more than a manufacturing campaign. It's a strategic vision to position India as a global hub for innovation, design, and protection of IPR. In this context, my presentation is how the synergy between Make in India and strong intellectual property rights can catalyze steel growth and enhance Indian position in global value chain. As you can see in the slide one, patentability of software under TRIPS agreement, justification and implication for SEPs. Sir, I'm trying to scroll my next PPT. How can I do it?
You can scroll it down, madam. You can easily scroll it down.
It's not. It's not, sir. It's not scrolling.
If
It's
you're
not, sir.
facing Dr. Renu, if you're facing technical issue, you can just present your PPT without presentation.
Sure.
You can
See,
go
sir,
ahead.
as you can see, my first presentation is about Making in India 2014, the 2014 vision. It is a manufacturing campaign and it is a strategic vision to position India as a global hub, as I mentioned earlier. So this slide, in the next slide, I just want to introduce how TRIPS reshaped global intellectual property standards, influencing India's legal reforms, innovation policy, and trade strategy under the initiative Make in India. With the outline, my research focuses on the software patentability, key jurisdiction like Alice Corporation case, challenges around proprietary models, open source, and SEPs friend issues. See, as you know, we are living in the innovation and knowledge economies, and TRIPS agreement was in the year of 1995 was a turning point, and Indian position was that time was not a good. So we need a strong and rather a very strong intellectual property regime to face the challenges that has been encountered internationally and nationally as well. So in the second slide, we will discuss the post TRIPS issues. That is how India revamped patent laws to align with global standards, especially pharma and software, contrasting proprietary and open source software. Along with this, I has mentioned a very important case that is about the jurisdictions such as USA, Canada, India, and European Union, and how the framework explore the intersection of software patent with standard essential patents, especially in the context of digital platforms, artificial intelligence, and global communication technologies. It also raises concern about the fair access and friend licensing obligations, competition law, and innovation equity, particularly in the developing country. So this issue has become more and more complex when software qualifies as a free and open software in one country is not recognized in the other country or elsewhere in the global platform, leading to a fragmentation and patent conflict. So my study concludes by advocating for harmonizing international policy approaches, particularly for the emerging economies like India, to ensure the balance between innovation incentives and public access is preserved. So it's a call for reimagining of patent standard that foster innovation growth in the digital era. So on the basis of my introduction, I have framed out some research question: how TRIPS agreement address the patentability of software and what international ambiguities arise from its provisions. Since my second research question, I derived how different jurisdictions, be it USA, Canada, India, and European Union, interpret and implement software patents laws, and what are the implications of their divergence. My third question is about the legal and economic standard of economic essential patents on innovation, particularly in the software and digital communication sector. And along with I also mentioned to what extent SEPs and friend licensing obligation, which is an important aspect of software patenting, promote or hinder equitable access to technology innovation, especially for the developing countries. See, along with because this is a very vast area and again it is full of challenges. So my entire research paper is based on the 6 core areas along with the outline of the broader aspects of software patenting. So how do software patent affect the tension between proprietary software model and open source movement, and what are the broader implications for digital innovation ecosystem? And lastly, what are the legal reforms that is needed to the not only to the national level, because along with the international organization and international platform, we need to harmonize the entire software patent regime and ensure inclusive innovation and access in the global era. So after this, if we will go through the entire perspective or historical evolution of the software patenting and the controversy on the software patent, along with we have to discuss the Paris Convention in the background and the issues of FOSS, free or open software, controversy due to section 27 of the TRIPS agreement, along with position of USA and EU, and SCP's landscape in India. How far? Little awareness of this commercial platform is required to earn a software freely or open earned income through providing software related services. See, if we'll see the historical background, 1960s till the time of 1969, when IBM unbundled software from the hardware, then we will come to know there is a boom of the commercial software, shareware, freeware, and public domain software. So fully free we have, along with the challenges of software, we are having some copyright issues as well. So when we set aside the free or open software for promoting freely and access modified sharing, there was a philosophy that when it comes to the collaboration, the distinction between free or open software has been blurred in practicality. If you using Linux require compliance with FSF and OSI licensing policy. See, again, if we'll come across the era of 1960s, then we'll come enter into the year of 2005. Then software patenting of under Article 27 of TRIPS agreement, we will share a lot of problem that is in the field of technology. But because on the one side we are developing in the pharma sector, we
Dr.
are
Renu, Dr.
yes,
Renu, just proceed with the challenges and its solution, which you have
yes, sure.
provided.
Challenges. Despite the global divergences, there is a key concern that remain consistent. Why software patent often blur the line between ideas and expression, as we have mentioned in the Alice Corporation case. Unlike copyrights, which protect only the expression of ideas, and patent protects the idea themselves, raising competition and accessibility concern. My third challenge is why patent can encourage investment and licensing, especially for SMEs, and they also inhibit downstream innovation, and particularly when granted too broadly. See, we have concept, we have seen also, and I do not want to go into the detailing of the broad patents. So little bit we are concerned only to the granted of too broad patents. The fast evolving life cycle of software often renders patented technologies obsolete and creating insufficiencies in innovating system, because of the broad patenting, and on the contrary poor granted software system, we are somewhere at the patent trolling system, because it exploits the ambiguity. It encourages the exploit of ambiguous or over broadly patents to extract realities and threaten litigation. As a result, if we'll go through the case studies, we will carve out the different parameters. So cut short, and I'm trying to carve out the conclusion part. So in the conclusion part, my research is entirely based on the challenges and what are the research question. According to research question, I have designed my research paper, that is, what is the legally binding and enforceable FRAND commitments in the SAP domain, then independent essentiality check and SAP valuation, a global framework for arbitration of SAP disputes, and a shared definition of software patenting eligibility that align SAP dispute with legal clarity. So ultimately, SAP are the central digital innovation nowadays in this ecosystem, and SAP holder licensing their patents on the FRAND terms. So ultimately, in this legal framework, we always found the uncertainty, and this is the question that we need to resolve, because it is the most scattered area, most disorganized area, where we need a coherent global legal framework sensitive to the development needs of developing countries like India, and where there is a need of inclusive innovation, which is imperative to ensure that software patenting support rather than stifling technological advancement across all countries, including that is India. Thank you.
Okay, Dr. Renu, I have one question for you. How does the TRIPS agreement, specifically from Article 27 to 30, addresses the scope of patentable subject matter, and
Yes,
does
sir.
it implicitly include or exclude software?
Yes, sir, that's very true. That is why I have mentioned, along with the TRIPS agreement, I have mentioned the Alice Corporation case, where there is a Supreme Court landmark judgment that why the abstract idea implemented on the generic computers do not qualify for patent provision under Section 25 of US Act. So court concluded in this landmark judgment that Alice claim lacked the inventive concept, therefore patent ineligible. That is why Ellis decision has a global implication, especially for the TRIPS compliant jurisdiction. But in the SAP case, there is a problem. It only touches the broader aspects of software ecosystem, not exclusive the legal framework for the SAP related matters, which is again very important and challenging area in the case of software patenting.
All right.
Sir, any more question?
No more. That's all.
Thank you, sir.
Thank you, Dr. Renu, for your presentation. Now, I would like to invite Advocate Ruthul Dev from Marcus Law College.
So, is it visible and audible?
Yes, you are visible and audible. Kindly share your screen, Mr.
Okay,
Arthur.
sir. Just wait 1 second, sir. Sir, is it okay? Hello?
Yes, it's visible. Start.
Okay, sir. Good afternoon to one and all. I'm presenting the topic Unifying the Innovations and Market Fairness, a competition law interventions against SCP abusing India's technology sector. First of all, we all know about the what you mean by the SCP and the abuse of dominance in competition law. Normally, to create a strong and flexible framework that support innovation and technological advancement while preserving fair competition, and policymakers, stand setting bodies, and competition authorities must together work together. For the future, it will be crucial for the foresee and in proactively handle the potential issues and related to SCPs. And also, navigating the future challenges will require establishing more transparent licensing, negotiation, establishing clear guidelines for determining front terms, and putting in place effective dispute resolution procedures. It all are the important for the keeping the SCPs in the IPR. And also there is a SCP holders are abuse their position in the days of the competition law. We all know the section 4 of the competition law, which is discussed about the abuse of dominance. The SCP holders are abuse their position to maintain the standard essential patents. And while we are looking to the standard essential patents are protecting technologies essential to meet established industry standards, and also they ensure interoperability and by providing standard interference protocols or functions, and also they are technologically critical for an entire industry's functioning. For the promote the uniformity and compatibility across the product and service, we should support the technological innovations and integrations and expansion and multiple market segments. While after that, we are looking to the legal framework which is in India. First, we should know about the Patent Act 1970, which is the primary legislation for the patent protection in India, and also grant inventors exclusive right for a fixed period of time to encourage innovations. And also, second thing is already mentioned the Competition Act 2002 for the fair market competition and prevent the anti-competitive practices, the to prevent the dominance and prohibit its abuse. It is the main thing for the interference of the competition law while we are looking to SCP and the competition law. The SCP owners require the license on the FRAND term, which is the fair and reasonable and non-discriminatory terms, mainly to prevent the SCP holders from the exploiting market power and exclude competitors or impose the unfair terms. The before we have said the SCP, we should know about the standard essential or standard essential patent, which give the standard setting organization, that's called SSO, which is to create and maintain industry standards. If a company has claimed exclusive right to standard, and industry adoption depends on that company's approval, such control can either open or restrict access to the standard for the others. And the front commitment, we should ensure that technologies are accessible to all potential users. That's the SSO transparency and collaboration promote fair competition, inclusivity, and innovations. And after after that, we are looking into the abuse of the dominance, section 4 of the Competition Act, which is forms of the abuse mainly include the patent hold up and FRAND licensing policies, and also royalty stackings. These are the main abuse which is find out from my research, which has happened in the SAP holders. And while we are looking to the challenges faced by the CCI while dealing with these things, first thing is the jurisdictional overlap, that the CCI role often overlap with the TRAI and other sectoral regulators and causing confusions and enforcement delays. And second thing is the rapid technological change, which requires constant updating of the regulatory approaches. And third one is the lack of technical expertise, which the CCI has no that much of expertise person for deals with the particular cases. That is the need for the deeper knowledge in emerging tech areas, especially in the digital economy. And also we should balance the interest, must protect the patent owners right while preventing the abuse of dominance by the powerful firms. And also policy tension, ensure the innovations and incentives and maintain open and competitive market. While we are looking to the other jurisdiction like UK, the SEP regulations says the SEP regulations are patents essential for the implementing technical standards set by the standard setting organization, which are applicable to the industries like telecom, consumer electronics, and automotive, etc. In the FRAND requirement, the SEP owners must license on the FRAND terms to prevent the market abuse, which is combined in UK, and issues guideline on the applying competition law to the SEP. There is an the act which is deals with the SEP's Patent Act 1977. And moving to the USA, SEP regulation, which is the history of the SEP, long-standing debates and litigation in the telecom and tech industries that has happened in the USA. After the 2013 DOH and US PTO statement emphasized the brand licensing and considered antitrust risk. While we are looking to the USA legal basis, which is also available to the patent law, grants the exclusive right to the inventors, and also antitrust law, which is explained for the Sherman Act Section 1 and Section 2, and the FTC Act Section 5. And while concluding my presentations, some recommendations for the India. First thing is the codify the FRAND obligations in the statute, mainly in the royalty calculation and licensing scope and safeguard, and also build the CCI technical capacity via specialized divisions or partnerships. And second, promote ADR mechanism to reduce litigations and costs. Third, establish coordination framework between CCI and sectoral regulations to avoid the overlap. And finally, recognize the global nature of the SCP ecosystems in the policy design. Thank you so much, sir. Sankam.
Okay, Mr. Rathul, I have one question. What is the legal standard for determining whether friend rates has been breached?
So actually, the terms, FRAN licensing terms, which is mainly fair and reasonable, which actually discussed in the patent and likewise also. But I'm not sure about that thing. I will be checking and I will be include my research papers, sir.
Also, one more interrelated question: can the excessive pricing of SCP licenses be challenged as anti-competition under any jurisdiction?
So once more, sir.
Can the excessive pricing of SCP licenses be challenged as anti-competitive?
Yes, sir. Yes, sir. Yes, sir.
Okay, and how? What would be the basis of challenging it?
So actually, the basis of challenging is that there is should be the violation of the SCP holders, sir. They should abuse their position, sir.
Okay, and who are the parties to go and complain? Is it the consumer or the parties to the SCP?
So I think it's parties to the SCP, sir.
All right. All right, Ratul. Thank you.
Thank you, sir.
Thank you, Mr. Rathul. Now I would like to invite Dr. Nitesh Singh from SDT University for your presentation.
Hello, I'm audible now?
Yes, Dr. Nitesh, you are audible, but you are not visible.
Hello. Yeah, good afternoon, sir.
Yes, you are audible and visible. You can start your presentation.
My slides are visible now?
Yes, your slides are completely visible.
Okay, okay. Thank you so much. Okay, good afternoon to all the learned members of the jury. I'm Dr. Nitesh Singh from SGT University, and my presentation title is AI-driven medical monitoring and smart dispensing system for rural healthcare. So, this invention is a smart health system for village that uses IoT devices to check patient vitals in the real time, and AI engine studies the data, spots problem early, and suggests the treatments for all the patients for the patients. Smart dispensers gives the right medicine automatically with the doctor's approval, and it works even with the low internet and solar power, and speaks local languages also. The goal is to bring the quick, affordable, and accurate healthcare to rural areas. And these are the main thing of this patents. And the main aim is to develop a scalable, affordable, and patentable AI-based system for rural healthcare, integrating the IoT-enabled wearable sensors for continuous monitoring, and implement AI algorithm for anomaly detection and predictive analytics, automate safe and timely medication dispensing, enable remote consultation and centralized oversight via secure cloud, ensure ruler adaptability and multilingual interface, solar power, and low bandwidth optimization. And the problem of this patent is that the rural areas faces the shortage of doctors, poor infrastructure, low connectivity, and medication access gap, and the current model limited by infrastructure cost and trust issues. Novelty and patentable features are closed loop AI dispensing mechanism linked directly to real time vitals, context specific adaptability, solar powered multilingual offline operations, and modular integrations sensors, AI core, smart dispenser, and cloud dashboards. And system overview and workflow is like this. The core components are IoT wearable sensors, ECG, BP, glucometer, pulse oximeter, etc. AI engines like anomaly detection, trend analysis of the things, predictive modeling, smart dispensers like secure, pre-authorized, tamper-proof delivery, and a cloud interface like remote monitoring, physician dashboard, and data security. Workflow is like
Mr.
this.
Nitish,
The
your
first
slides are not moving.
uh,
Yeah, it's moving now. Yeah.
now it is visible, sir. Like
Yes, yes,
this,
visible.
this one is the aim of the patents, and this one is the problem that the rural areas faces the shortage of doctors, poor. I already mentioned these things. And the novelty of this patent is closed loop AI dispensing mechanism linked directly to the real time vitals, context specific adaptability, solar power, multilingual offline operations, and modular integrations like sensors, AI core, smart dispenser, and cloud dashboards. And these are the core components of this, which I already mentioned. And this slides present the workflow. Like the first, the sensor will capture the patient's details, and then the data will be sent to AI engines, and then AI will analyze the things, and alerts and medication instructions will be given, and then the remote physician will validate the things, and the automated dispensing plus patients notifications will be given to them. And the impact is like 40% fewer unnecessary referrals are there, 60% increase in early disease detection, reduced travel burden by 80%, 60 to 70% improvement in medication adherence. Applications are like rural health kiosks, mobile healthcare vans, disaster relief medical units. And the patent scope is like method and system claims for AI driven closed loop health monitoring and dispensing. Hardware integration claims for modular sensor dispenser units, and software claims for AI or algorithms, multilingual interface, and low bandwidth operations. Thank you so much, sir.
Okay. So, Mr. Nitish, there is no question from my end. Thank you for your presentation.
Thank you so much, sir. Thank you. Thank you.
Thank you, Dr. Nitesh. Now I would like to invite Miss Darshita and Mr. Pratyush for the presentation.
A
Yes,
very good
Mr.
afternoon.
Pratyush. Yeah, you
Yes,
can present your screen.
yes, sir. Just a minute. I request Ms. Darshita if she is able to present the screen, please.
Miss Darshita is not visible in the dashboard.
Ms. Darshita, are you there?
So, Miss Darshita is not present in the StreamYard.
No, no, she was present.
I'll
I,
coordinate.
please, please, please.
Okay, yeah, she has joined now. Yeah, Miss Darshita, can you present your screen?
Yes, sir. So is my screen visible?
Yeah, it's visible. Yes,
Okay.
go ahead. Start.
Thank you, Darshita. Okay. So good afternoon to everyone. I would like to begin this presentation with a very short story that in a remote village, a young doctor named Anya dreams of a future without preventable death. Her hospital, built with immense efforts, lacks the most basic modern tools. Her hope arrives in the form of a new, low cost diagnostic scanner, a device that runs on a globally recognized standard for medical data transfer. The scanner is lifeline for all the villagers, but its license is a labyrinth. The technology is protected by standard accessional patent held by MNC thousands of miles away. The company insists on a FRAND royalty base, and the rate that is fair for MNC is based on the profit margins of hospitals in developed nations. To Anya's hospital, this rate is not just a high cost, it's an impossible one. Each payment means a high cost. It's there will we have to remove the nurse. We have to be a one less vial of medicine. The promised lifeline feels more like shackle, and the reasonable terms are threatening to keep the most crucial medical technology out of the hands of those who need it most. This story forces us to ask one major research question, that is, when a patent protects a technology essential for human health based on any kind of technology for this presentation, be it IoT, how do we define fair? Is the price of progress a premium that the most vulnerable must pay? So, our presentation, the framework of our presentation is based on the foundation of SEP, the challenges of developing countries with respect to SEP, what are the existing solution for FRAND, and the best part of our presentation is our innovative idea of BAD framework, which is based on three hows. First, how to determine FRAND, how to execute FRAND, and how to enforce FRAND. So I request Ms. Darshita to please go ahead.
Thank you so much, sir. I hope I'm audible. So, as my co-author explained, that the basic theme of our paper is to ensure that the SEPs are licensed on FRAND terms. SEPs, we all know, are those patents that are very important or indispensable
to comply with the technical standard. They are very important to ensure interoperability and seamless communication. FRAND commitment, that actually stands for fair, reasonable, and non-discriminatory terms, is actually a commitment that ensures fair return to the SEP holders and an equitable access to the implementers. So more or less, it is a promise that balances the innovation incentives with market access for new technologies. Now, what are the persisting issues that exist in the SEP licensing world? So the three basic issues are the unclear nature or the ambiguous nature of FRAND. Despite the fact that FRAND is one of the most crucial element when it comes to SAP licensing, there is no proper or definite definition to describe what actually is what is mean by FRAND. So that means the stage is open. A person can come and interpret it keeping its own favor or keeping its own interest in its mind. So because of this, the developing countries suffers a lot. Second comes patent holdup, a practice that is very common with SEP holders wherein they exploit their market power to demand excessive royalties from implementers. Then comes the third issue, patent holdout, that actually describes the opportunistic approaches of the implementers where they try to strategically delay or refuse the negotiation of SEP licensing to ensure two things. First, suboptimal rate of royalty, and second, not giving any royalty at all. So these are the issues that exist. Now, how are they impacting the developing countries? As Sir told in her story, patent may be territorial, but technology, that is global. And every country, every in this world wants to get access to these technologies. But developing countries are the net importers of technology. And if the licensing agreements that allow them or to access these technologies is not clear, is actually ambiguous, then that will pose a good threat, especially a financial threat towards these developing countries. So the core challenges that actually exist for developing countries or economies, as I stated earlier, the monopolistic behavior and hold out by the SEP holders, wherein they try to exploit their dominant position. Then comes the issue of over declaration of patent. Again, this is a common practice. For example, in 2004, out of all the patents that were declared as SEPs for 3G, only 21% patents were actually essential. 79% were, you can say, valid patents that have been framed essential patents only to ensure a more benefit for the SEP holders. So over declaration of SEPs actually inflates the licensing cost and creates a significant uncertainty, especially for smaller businesses and startups in developing countries. Then come the main bone of contention, that is the ambiguous nature of the FRAND terms. So question could be how to govern it, whether we should look for the market forces or we should look for the regulatory bodies. Now, both these solutions have their limitations. If we go for the market forces, then unregulated markets can be a good threat for developing economies, because then the royalty rates will be determined by those markets that are in themselves anti-competitive. Whereas if we will not properly address or watch the intervention of the regulatory forces in the FRAND terms, then the autonomy that is very important when it comes to SAP licensing will be hampered badly. Now comes the rise of IoT. So the Internet of Things, the idea. This idea is no more an idea on the horizon. It is rather a persistent reality. Currently, as per the study, 19.8 billion devices are connected to Internet. And this is supposed to grow by 40 billion by 2030. So in 10 years, more than double. So we can say that everything around us is connected with Internet. And in this era of Internet, it is very important for all the countries that they have access to technologies. So the question of interoperability and seamless communication becomes very important when we consider the current situation, that is the Internet era, which is going. Therefore, we are saying that what are the existing approaches? Okay, so we know what are the issues currently existing in the SAP licensing world. So what are the existing approaches? What are the gains and what are the gaps? First approach, domestic regulation, plus point. It can tailor as per the domestic needs. But the negative issue is that it could lead to fragmented and inconsistent global outcomes, which will create legal uncertainty for international tech companies. Second comes patent pooling. You can say it or describe it in one word as one-stop shop. So it does reduce the transaction cost. It allows one person to go to a particular place and can get all the patents that he wants, but it may lack full SEP coverage, and it carries with itself certain antitrust risk. For example, if pool becomes too dominant or it might exclude essential patents, then that behavior will be, of course, anti-competitive and will not be very helpful in the long run. Third comes compulsory licensing. A boom, no question. It is a very good solution, but it is a solution that can be used only in emergency cases or in a dire public interest. This can never become a practical and day-to-day solution for all the technologies that are becoming a standard and for ensuring FRAND licensing. So what we can say as a bottom line is that all the current solutions that already exist fail to provide a robust or a predictable framework to determine the licensing agreement as FRAND terms. So after this, we studied three countries, the judicial and policy responses toward the SEPs and licensing. So the three countries that we covered in our paper were India, China, and South Africa. So when we deal with India, if we look at the India's response toward the SEP licensing, we can say that there is a judicial sovereignty, good faith negotiations are emphasized, competition laws are used to regulate the SEPs and licensing terms, and of course, case-to-case basis, the court decides the matter. So there is no absolute or no definite regulatory framework or a statute to govern or to describe what.
Ms.
Yes, sir.
Dakshita, you can move to the solutions and recommendation.
Sure, sir. The solution that we are coming up is actually the BAD framework. So what does BAD means? BAD is an acronym, whereas B stands for biased, A stands for arbitrary, second A stands for anti-competitive, and D stands for discriminatory. So this BAD defines what FRAND is not, which is a negative approach to a positive principle, providing a clear diagnostic lens for unacceptable licensing practices. So how does this BAD framework actually works? It analyzes the licensing conduct, moving beyond theoretical discussions to facilitate proactive compliance and, of course, fair negotiation. So what will this BAD framework look for? The BAD framework will look for the good faith negotiations, the transparency, consistency, economic justification, which is, of course, very important from the perspective of a developing country. And the fifth one is impact on the competition. So we can say the BAD framework is like a digital referee. What we have proposed in the paper is that we must incorporate this entire framework into a smart contract. This smart contract will use the real world data to check if the proposed patent royalty rate is bad or not. So if the royalty rate that you are proposing is bad, that means it is not FRAND and must not be applied. If it is not bad, then that means it is FRAND. So what it does not set the final price. So if you see other courts or any court that intervene, what they do, they set the final price. We should avoid it because autonomy is the most important part of SEP licensing. We should not completely eradicate autonomy, but we can restrict autonomy because that will ensure that the rates, licensing rates that are determined are not bad. That is biased, arbitrary, anti-competitive, and discriminatory. So what it will do is that we will feed this AI, the smart contract, with the collective database of past licensing deals, court rulings, and market data. And based on that, it will provide whether the licensing rate that the SEP holder is proposing is FRAND or not. How it will work, I have given examples, if you can see on the screen. The first is biased. If you want, I can explain them. For example, in biased, a car manufacturer, he needs a patent for a specific Bluetooth technology. The smart contract will look at the database of similar manufacturers that have licensed the same patent, and it will see that the average royalty rate for those companies is about $1 per car. So if the SEP holder is asking for $5 per car, the smart contract would flag this rate as potentially biased because, of course, it is more than the average market rate. Second comes the arbitrary. Our smartphone maker is asking to pay a royalty of $7 per phone. And when the patent holder asks why $7, if the patent holder could not justify it, it is unable to provide a document or a formula or a calculation to back that number, then the smart contract would flag that rate as arbitrary because it has no logical basis. Third comes anti-competitive. If a patent holder has a patent essential for a smartphone's camera and they offer a license to a phone manufacturer, but only the manufacturer also agrees to use the patent holder's non-essential patent, more or less like anti-competitive bundling. So the smart contract would be programmed to recognize this kind of bundling and flag it as anti-competitive because it unfairly forces a manufacturer to use a specific service. The last, discriminatory. A large TV manufacturer is given a royalty rate of 5% per TV for video compression patent. Now, a smaller new TV manufacturer that sells a smaller number of TV is asked to pay 10% for the same patent. The smart contract will again look at both the companies and see that they are similar in size and product and thus flag the rate as discriminatory because the two companies are not being treated equally. So this is what we are trying to propose in our paper. That is the bad framework that actually transforms FRAND from an abstract principle to something that can be enforced, a benchmark that ensures fair play in the global SEP landscape. And by incorporating them into smart contracts, we can automate transparent payments and flag inconsistent behavior, thus creating a technologically future-ready licensing ecosystem. Thank you.
Okay, thank you both of you for your presentation. My only one question for you guys, specifically when we see the economics in a developing country and a country which are already developed, it's like their dependency on the SAPs and their dependency on the other patents are very widespread. For the developed country who are well developed, they are more dependent on the technologies. But for India, developing country, and all the underdeveloping it, they are yet to get that dependency level. So along with their dependency on the technology and their technological advancement, there are various parameters to adjust the SEP rates and also to fix the rate of their standard essential patent in their countrywide. Like in the country where the demand is so high for their technology, definitely the SEP rate would be higher. And for the countries like India, where the demand is growing nowadays, it will go higher. But it is till now not as high as compared to the developing countries like US, UK, and the others. So, like my question to you both is: should WIPO and WTO create a special SAP fraud guidelines, FRAND guidelines for the developing countries to promote both innovation and market fairness? Should there be any guidelines in relation with the SAP and FRAND, specifically for the developing country?
Yes, sir. You may answer.
Thank you very much, sir, for your question. See, sir, definitely we need a guideline for developing countries, and not only developing countries, but also underdeveloped countries. Your question reminds me of one of the lectures that I used to give to my student based on technology transfer. So if we don't transfer know-how to developing countries, the consequences is based on these SEPs factor, as you rightly asked us regarding that. So first of all, we need a guideline, but that guideline must be feasible. That is why we have come up with an idea of BAD, that is how to enforce, how to execute, and how to determine. So we can say that we need a guideline, but we need a feasible guideline so that developed countries won't abuse their power while using SEPs. So definitely, sir, the answer is yes. But behind that, we need to obey the TRIPS agreement. We need to obey WIPO's guideline. We need to obey even some of the treaties or conventions that are based on environmental legislations, like Stockholm and other, who says that technology transfer is essential, that can be linked with IP systems, sir. I hope this addresses your
Okay.
question.
Along with that, one of the very intrinsic link question, as per my understanding of your topic, you can also include SROs, SRO, self-regulatory organizations. So recently, what we see, all the developing technologies, it may be the fintech, it may be the other like intersection technologies. All of them are having their SROs. Even the for the fintech revolution in India, the last year itself in 2024, if I am not wrong, in the month of November, like in October to November, the government has like notified the list of the SROs for regulating the fintech. In a similar manner, like the WIPO, also the WTO can come up with the SRO regulations for monitoring the SCPs. Because when we talk about the standard essential patent, or when we talk about the fintech, these are the subjects where the expertise is required much. Where like a random person having a legal background or having a diplomatic background, let's say diplomat, they cannot like know the intrinsics of that technology. There must be some specialist from that field itself, which the self-regulating organization can do. So this is one of the things which you can which you guys can look into. You can like make a comparative study in response with the fintech. Right now the government has published the SROs of the fintech, and then you can prepare your recommendations accordingly.
Sure, sir. Thank you very much for your recommendations, and we'll incorporate it. And we are also, this framework is based on two methods, that is preventive and curative, like before SEPs and when it executes. So we'll definitely incorporate this SRO factors. So thank you very much, sir, for this suggestion.
Thank you, sir.
Thank you, Mr. Pratyush and Ms. Darshita for your presentation. Now, I would like to invite Ms. Shivangi Singh from School of Law and Legal Affairs, Noida International University.
Shivangi, please unmute yourself and turn on your camera.
Am I audible?
Yes, you are audible, but you are not visible.
Please give me a minute.
Please be fast, Ms. Shivangi.
Am I visible now?
Yes, you are visible. You can present your screen.
Okay, sir, I'll be presenting.
Kindly be fast, Ms. Shivangi.
Is it visible now?
Yes, it's visible now. You can present.
Okay. Okay, very good afternoon to everyone. This is Shivangi Singh this side, Assistant Professor, School of Law and Legal Affairs, Noida International University. My topic today is Balancing Innovation and Market Power, a comparative competition law study of abuse of dominance and FRAND compliance in the SEP ecosystem. First of all, we need to understand what are SEPs and why do they actually matter. SEPs, or the standard essential patents, are patents that are indispensable for complying with a technical standard. For example, in 5G, Wi Fi, or USB technology. Because everyone is actually implementing the standard, they must use them. SAP holders, they're actually enjoying de facto monopoly. That's why many standard setting organizations, they are requiring them to license on FRAND terms. What is basically FRAND here? Fair, reasonable, and non-discriminatory terms. These terms are very much important in order to balance access with innovation incentives. Now, moving on further to what is the challenge here. Challenge here is basically the enforcement. FRAND is basically lacking a universal definition. Dispute is arising all over the world regarding what is reasonable, what is non discriminatory, and how to calculate the royalties. and whether injunctions are fair in nature or not. Abuse in the domain, it can occur basically through excessive royalties. Basically, we can take the example of patent holdup, stacking of multiple royalties, also refusal to license or coercive NDAs, that is non-disclosure agreements. Talking about basically what has been the India's approach so far regarding the SEPs. We have seen in cases like Microsoft and Intex versus Ericsson, the CCI, that is the Competition Commission of India, it has investigated unfair royalties, particularly when it tried to calculate on the entire device value instead of the small patent practicing unit SPPU. But the Delhi High Court, in this very judgment, it later ruled that such matters will not fall under the purview of the competition law, but they will be falling under the purview of the Patent Act. Now, this actually led to the CCI role being very limited, and this judgment basically fragmented the CCI's role overnight. It also led to some procedural gaps and reliance solely on injunctions, which created quite uncertainty for local manufacturers. Now, moving on to the EU's approach, European Union's approach. Talking about the EU approach, it is more structured in nature, and it being a very mature jurisdiction regarding to the SEP ecosystem. In Hawaii versus ZTE, the Court of Justice of European Union, it has basically laid down a negotiation protocol, such as the SEP holder will notify the implementer, he will make a FRAND offer, he will allow a response from the uh, implementers, and only then he will be able to seek an injunction. The European Commission has also taken cases from Samsung, Motorola for abusing these protocols and for abusive injunctions. So basically, EU's approach is more transparent in nature. It is analyzing economically, and they have laid down procedural standards which are very central in nature. Talking about the United States approach. United States is basically more focusing on the contract and the patent law. In the case of Broadcom versus Qualcomm, it has recognized deception of SSOs as potentially anti-competitive. These standard-setting organizations, they were basically recognized as anti-competitive after they were deceived. FTC versus Qualcomm Limited antitrust use. Courts like in the case of Microsoft versus Motorola, the US courts, they have basically focused on economic valuation methods for royalties, but they don't have a formal negotiation protocol like in the European Union. This preserves strong patent rights, but it is offering very few options or very few protection to the implementers. Talking about basically the comparative insights. Talking about first of all of the EU. EU has a more procedural, intervenist, and a negotiation focused, talking solely about the SEP ecosystem. Talking about the US here, it is more contract driven. It has minimal antitrust intervention, minimum competition intervention. Talking about India, India is basically following a hybrid approach. It is lacking any statutory clarity and coordination, but it is more hybrid in nature. The common grounds here actually is all these three nations here, that is the EU, US, and India, they are trying to value transparency. They need to have more objective royalty benchmarks. They should try limiting the abusive injunctions, and they should try to encourage the ADRs. talking about basically what will be my reform proposals here, or the recommendation is that the countries, they need to codify FRAND principles in their very national laws. Second, they can create specialized SEP tribunals. Third, they can mandate early royalty disclosures. Fourth, they need to maintain a global licensing database. Next is basically they need to prioritize third party litigation, or basically they need to focus on ADR in order to resolve any sort of disputes. And the last one is basically they can explore a WIPO led soft law framework in order to harmonize the global norms. I would like to conclude here by saying that SCPs, they are crucial for innovation, but if they are remained unchecked and if they have unchecked market power, they can really harm a competition. Hence, a balanced, coordinated, and transparent legal approach nationally as well as internationally is very essential to ensure SCPs serve both technology creators and the broader public interest. Thank you so much.
Okay, thank you, Ms. Shivangi, for your presentation. My question to you, like how the abuse of dominance, as it is defined in Section 4(3) of the Indian Competition Act, like is applicable on the SAP licensing when we see the license rate are much higher, and the monopoly is being used by the companies, by the parties of the SAP holders. So can it be enforced? Can the competition law be enforced in on those grounds, like the high license rate and ultimately the monopolization of the market?
So, thank you for your question. So, basically, we don't have any friend legislation in any nation, in India, in US and EU. EU is the most closest because it has basically framed a protocol in one of its cases, wherein it is basically telling about what a SCP holder needs to do. Talking about your question, basically, sir, if we talk about India, in Indian cases, basically the courts, they have ruled out that the SAP is a matter of patent laws and not of the competition law. And talking about the US courts are basically saying that it is more contract driven and basically applicable with the patent laws. EU is the closest to the antitrust. So basically, sir, talking about your question, that is the abuse of dominance. Actually, first of all, we need a specific framework. The courts in many nations, including the India and the US, they have actually failed to understand that SCP is actually falling under one of the purviews of antitrust and the competition law as well. So, I would like to say that first of all, the courts need to understand that even SCPs are constituting abuse of dominance and they need to be addressed. Have I made myself clear, sir?
Yeah. All right. Thank you.
Thank you so much, sir.
Thank you, Ms. Shivangi. Now, I would like to invite Mr. Apoorv Mishra from Dr. B.R. Ambedkar National Law University, Haryana.
Yes, Mr. Apoorv, you can present your screen. Apoorv, your voice is not audible.
So can you please tell me whether my voice is clear and my PPT is visible?
Yeah, your voice is clear and PPT is visible. You
All right,
may start.
just a second, sir. All right. So, very good afternoon to everyone. Today, I'll be presenting a paper on evolving jurisprudence of standard essential patents and its impact on international patent law. So, the focus will be on how SCP have developed globally at the role of FRAND principle and the comparative legal approaches in different jurisdictions. In today's globalized world, standardized technologies are the backbone of the modern communication and trade. SEPs are the special patents that are necessary to use certain technology standard. To keep things fair, SEP owners promise to give license on FRAND term, that is fair, reasonable, and non-discriminatory. In my research, I looked at how countries like United States, Germany, India, Pakistan, and Bangladesh handled SEPs and how laws, court cases, and standard setting bodies shaped these rules. So, in our connected world, from phone and the internet to cars and smart devices, standards are important so everything works together. But there is a problem. Patents give exclusive rights while standard needs to be open. So, the challenge lies in balancing patent right with the fair competition. FRAND rules tries to fix this by stopping unfair behavior like charging too much after the technologies became standard and also stopping companies from refusing to pay fair. Groups called standard setting organization ask members to share such patents and agree to license them on FRAND terms. The main purpose of is to like prevent two major risks. The first one is patent holdup, that is where a patent owner demand excessive royalties after the standard is set, and the second is patent ambush, where implementers tries to avoid paying the royalties. But the main problem is there is no single formula for what is fair or reasonable, so each case is decided differently, often in the court. So now let's compare the key jurisdiction. In the United States, SCP law is litigation driven, focusing on determining reasonable royalties with injunction rarely granted. There are landmark cases like Microsoft versus Motorola and Apple versus Samsung have influenced SCP law here. And there are antitrust bodies like US Department of Justice and Federal Trade Commission to keep check on the unfair practices. Now we'll talk about the Germany. Germany follows a strict rule-based framework from a Huawei versus ZTE case, requiring step-by-step FRAND negotiation, where SCP holder must notify the infringer, prove the patent essentiality, and offer FRAND terms in writing. Implementers must show the willingness to license, respond promptly, and provide security for past use. And skipping any step can lead to losing right or facing serious consequences. So this clarity makes Germany a preferred venue for SCP litigation. Now we'll talk about our country, India. India uses a hybrid model where court balances patent right with competition law, often allowing interim royalties while the case proceeds. Court often allow continued use of technology if interim royalties are paid. This was stated in Ericsson versus Micromax case. There is Competition Commission of India, which actively investigates unfair licensing practices. And the disputes can be handled both under the Patent Act and the Competition Act. So we can say India is still developing its SCP laws and combining like patent law with competition regulation. And now we'll talk about the condition in Pakistan and Bangladesh. Pakistan and Bangladesh are still in early years, using general patent laws without any SCP specific regulations. They totally rely on the general patent laws. So these differences create legal landscape for multinational technologies companies. So SCP rules are shaped by three things, starting with laws made by the government, court decision, and the rules standard setting groups. Over time, the FRAND promises has gone from being just a voluntary agreement to something court can enforce like a law. So at last, I'll talk about the challenges and the future development. So the biggest challenge is that countries follow different rules, which make it hard for companies working in many places. This can lead to forum shopping, where companies choose a country that benefit them the most. Working and my proposal is like the working together globally through organization like World Intellectual Property Organization or World Trade Organization, and making common guidelines could make things easier and fairer. And to sum up the presentation, SCPs are the key to make global technology work together. And without them, innovation would be impossible.
Okay, Mr. Apoorv, I have one question for you. Am I audible to you? Mr. Apoorv, am I audible? Manik, am I audible?
Yes, sir, you're audible. I think there's some lag from Apoorv's end.
Okay. I don't think that a network will come up. We can move with the next participant.
Sure, sir. Next, I'd like to invite Dr. Gargi Bhatt from Delhi Metropolitan Education, Noida.
Hello, good afternoon.
Yes, Dr. Gargi, you can share your screen and present.
Yes. So that option for sharing is not coming in my device.
Are you presenting from your phone?
Yes, sir.
Okay, then you can provide your PPT later on the mail. You
Right.
can present without your PPT.
All right, sir. So, but am I visible and audible to you?
No, you are not visible. It's showing black. Yeah. Now it's
Okay.
visible.
Uh, all right. So my topic is WIPO's role in harmonizing SEP disputes. Is it a myth or a possibility? Am I audible?
Yes, please go ahead.
All right. All right. So, sir, what I have done in this paper of mine or an article that I've written, I've highlighted and I've studied that the role that WIPO, that we all know, World Intellectual Property Organization, how is it, uh, understanding and deciding over the rising disputes and the disputes with respect to licensing, fair terms, these kind of issues are at a rise, especially with the technological developments that are happening with these emerging technologies of AI and IoT. We have seen that the disputes are at a very higher rise. Although we know that WIPO's role currently is to administer the international treaties, and one of the main role is to provide arbitration and mediation services. But the challenges that we see here is what I have incorporated in my article, that there is a lot of issues with respect to jurisdictional differences. And there are different interpretation of FRAD terms. Now there are conflicts between the national courts that are happening. There's complexity of technical and economic issues also, which are at a very high rate and coming up. Now, the potential role of WIPO under all these issues is that they should create a standardized SEP dispute resolution framework. Although they are promoting that, FRAD definitions of generally should be adopted, and there should be an encouragement in the mediation and arbitration proceedings over, going behind litigation again and again, even for a smaller dispute. Basically, what I have tried to put in is whether this role is going to be a neutral global platform for all disputes arising out of it. Now, when we talk about harmonization, we are working towards encouraging fair licensing globally, improving the efficiency and predictability, strengthening the trust in this international IP system. Although, with the same things that we are looking in the positive manner, what we come across is that there are concerns of national sovereignty. There are different economic interests between the nations, especially the developing and the developed nations. And there is also resistance from powerful jurisdictions. Like a nation who is at a different stage of development already is might create restriction to permit other jurisdiction to enter into their market, right? Now, the topic where I'm discussing is whether it is a myth or a possibility. Under this, what I have come across and I have written in my article also for till now is that the harmonization that we are expecting at a full level amongst all the nation might not be possible in very near future. It is very unlikely. However, partial harmonization is possible to look at it in a realistic manner. Now, this WIPO can influence norms, but it cannot impose any stringent or permanent rules on different nations altogether. So we should apply a realistic path that is, apart from arbitration, which might also take, in different time zones, something that is practice would be a mediation proceeding. So WIPO's role can be more of a facilitator than an enforcer. They should be able to facilitate these issues properly. And harmonization, as we all understand, is a very gradual process that can happen, with step by step development. And we need to focus on collaboration between nations, industries, and WIPO. And possibly we can say that mediation will be a big assistance in all these cases, and although not extremely happening immediately, but it is a step by step process that we can take it forward. So this is what my paper is all about, and I am looking forward to more of your suggestions so that I can incorporate in it.
Yes. Dr. Gargi, I have one question for
Yes,
you.
sir.
What institutional or political obstacle prevent WIPO from establishing a unified SEP dispute settlement process, if there is any in your mind?
So, political issues will be numerous because in the current scenario of the current lifestyle, also we have seen with respect to development, if we are looking for any nation, on one stand, one nation might be developing at a really different stage and scenario. And the development happens not only with the innovations that are happening, but how the people are also getting employed in different countries, right? What are the rules that are changing, especially with respect to the new rules of the USA that are being introduced? There has been total difference amongst most of the nations. So coming to a one uniform set of rules is something that is something that we are hopeful for, but it will take certain maybe years. So we are being very optimistic about it. But in the current scenario, if we see, so we need to look at what is the problem in the hand and how to deal with it, sir.
Okay, and the suggestions specifically for your paper is like you should include one of the portion which is in the recommendation where the WIPO's main objective is to bridge the gap between the developing and developed countries.
Right.
Like if you see into the objective of WIPO and the purpose for which the WTO and WIPO such organization has been made, so like whether that objective is getting fulfilled when we see the recent developing innovations and the technological advancement like SEPs, which is the need
Right.
of an hour. In
Right.
today's generation, we cannot even sustain without any gadgets. And when there
Right.
is gadgets, there has to be an SEP or the patent innovation.
Right. Right.
So you have to make the assessment whether the SEP enforcement and FRAND like negotiations or the FRAND licensings are
Hmm.
complying the objective of the WIPO in the present day scenario. If it is not, what are the consolidated recommendation and suggestions as a scholar or the researcher, how we can provide it?
All right, sir. I will definitely incorporate this also in my paper.
Okay.
All
Thank
right.
you, doctor.
Thank you. Thank you so much for your time, sir. Thank you.
Okay.
So one more person is left. Dr. Diksha is left. She was there in the StreamYard link, but she just left. Oh, she has joined. Okay. Now I would like to welcome Dr. Diksha Mishra.
Dr. Diksha, you can turn on your camera and unmute yourself. You are not audible, Dr. Diksha. No, you are not audible, Dr. Diksha. You are not audible. check whether you have unmuted the option. You are still not audible, Dr. Diksha. Okay, you can try, Dr. Diksha, try rejoining it. We'll be waiting for next 2 minutes. Yeah, you may try rejoining. Manik?
Yes, yes, sir.
Okay, till that time, tell me how many participants are present today?
1 second, sir.
Okay, Dr. Diksha.
Sir, 14 have presented so far.
Okay, 14. All right. Okay, Dr. Diksha, now you try to connect, turn on your camera and unmute yourself. You are not audible, madam. If you are facing issue with your desktop, try to connect it via phone. Because you are only the last participant left. Yeah, try to connect it via phone. Yes, Dr. Diksha, try unmuting yourself and speak something. Unmute and speak something. You are not audible, madam. You are not audible. Manik, can you just look into why this issue is happening persistently with her?
Yes, sir. Chandrasekhar is coordinating with her.
Okay, okay. Yes, Dr. Diksha. Now try. Okay, Manik.
Yes, sir.
If it is persistent, then we cannot consider her any further because it's delaying our program.
Sure, sir. Sir, should I give the vote of thanks then?
Yeah, proceed with the vote of thanks. Just like tell her that she can mail the authorities regarding the issue she had faced, and the administration will look into it. No
Sure, sir.
issues. She will not be
Sure, sir.
marked absent. Okay.
Sure, sir.
Yes, proceed with the vote of thanks.
As we conclude this insightful session of the International Conference on SEPs and Patent Innovation 2025, I would like to take a moment to express my heartfelt gratitude to everyone who made this event a success. To all our speakers and panelists, thank you for sharing your expertise and perspective on the complex and evolving landscape of SEPs. Your contribution have truly enriched today's discussion. A special note of appreciation to the Naovina Development of Intellectual Property and Research Foundation, our collaborators, Global Innovation Policy Center, and Open Invention Network, and to our visionary founder, Mr. Dipendu Das, for their unwavering commitment to fostering dialogue, research, and innovation in the field of intellectual property. This conference stands as a testament to the leadership and dedication. To our technical team and organizing team, your meticulous coordination and behind the scene efforts ensured that the event ran seamlessly, and for that, we are deeply grateful. Lastly, I encourage all participants to remain connected and engaged as the second South Asian Global Intellectual Property Summit continues to unfold with more thought provoking sessions and collaborative opportunities. For updates, please visit our official website and follow us on our social media channels. Once again, thank you all for your presence and active participation. Wishing you a productive and inspiring journey ahead in the world of innovation and intellectual property.
Okay, thank you, Manik. So, Manik, like if Dr. Diksha is audible now, we can take up one of the exception cases and take up our presentation. Just
Sure.
for, yeah.
Yes, sir.
Thank you so much. I'm really grateful for giving the opportunity. I understand there was some lag from my side. I'll just take a minute and share what I wanted to discuss in my presentation. So, my presentation was related to patent eligibility for microbial invention. So, microorganism they have been used in industrial application for the longest of the time, but it is because of the advancement in green technology, carbon neutral technology. Now the usage of microorganism has increased and microbial innovation has also increased. The advancement now needs more protection. In very short, I'll discuss that. Of course, we all are aware that microorganism they were excluded from subject matter of patent in Indian Patent Act, but it was only after the 2002 Amendment Act wherein microorganism were included by making a carving provision under Section 3 Clause J of Indian Patent Act. And of course, we are signatories of TRIPS, and by virtue of Article 27, microorganism has been considered as a subject matter of patent now. Now, the recent judgment of Delhi High Court in the case of Regent University of California versus Controller of Patent, what has been done there, that there was the Regent of University California, they sought patent protection for a Salmonella recombinant microorganism, which is useful for preventing enteric diseases in livestock. Now, their patent application was rejected by Controller Patent, taking the plea that the disclosure requirement has not been fulfilled, a disclosure requirement under Section 10, Clause 4 and 10, Clause 5. So now this Section 10 it expects a patent applicant to ensure that the specification in the patent application are broad enough to enable a person skilled in art to carry the same invention. This is one of the requirement of this is one of the disclosure requirement. In addition, if the specification and the claims are not adequate enough, then they have to also submit a sample of their invention, in this case a microorganism sample, because we are signatory of Budapest Treaty, which mandates the deposition of microorganism sample in with international depository authorities. Now, in this case, their application was rejected on this ground, and also that they have rejected application on the seeking taking plea of Section 3 Clause C. When the Region University of California, they went for appeal in Delhi High Court. There, Delhi High Court has also taken the same opinion and has upheld the judgment of upheld the ruling of the controller patent. Now, interestingly, very brief, I would like to bring in notice that the same subject of patent application, the subject matter of this patent application has been granted protection under US jurisprudence, under US patent and US PTO, US Patent and Trademark Office, as well as under European Patent Office. Now, is there a difference between the jurisprudence that Delhi High Court has followed and the one which is followed by under European Patent Convention, or for that matter under US law? Article 83 of European Patent Convention also mandates disclosure. That also mandates that disclosure should be broad enough. They should not be narrow. They should not be vague, and should enable a person is skilled in art to carry same invention. Likewise, in US also, in the case of Agilent versus Sanofi, has also held the same. Now, the jurisprudence that is followed by US and European is same, and the same jurisprudence has been discussed by Delhi High Court. But if the same subject matter is not getting patent protection in India, it means, by the Indian court, it means that somewhere there is some lack. We need to understand that the line between the giving protection to natural microorganism and a recombinant is very blur. We need to encourage research and development in biotech industry, and biotech patent need to get patent. So now what has to be done as far as recommendation and implications recommendations are considered? So the major drawback that is found or the controversy around the judgment is that there should be some evidentiary basis based upon which the controller patent or Delhi High Court, they should have rejected the patent application. When they say that the disclosure are broad, there should be some evidentiary basis based upon which the applicant can prepare their rebuttal. Indian Patent Office, they should be trained in a way that they should reject patent application before after giving, as I said, after relying upon some evidences. Secondly, in this case, they failed to submit the recombinant salmonella, the sample with the that is a mandate of Budapest Treaty. So the applicant, they should be made aware or informed about the submission, and they should be ready beforehand. So there must be awareness among the new startups, among the biotech industry, so that we can make them well versed with the disclosure requirements. Because as we know, the more the jurisprudence is that the more you disclose, the more you have to enable in sense through the disclosure requirement. So this is something that we have to ensure that all the stakeholders are made aware about the nuances of seeking a patent in a as far as microbial innovation are considered. That's all.
Dr.
That's all
Diksha,
from my end.
yeah, my question to you is, what constitutes sufficient disclosure under Section 10 of the IPA, मतलब Indian Patent Act, for the microbial invention specifically? Like, is it the same disclosure or the other kind of disclosure will constitute a sufficient disclosure for the microbial inventions?
The source and the geographical origin of biological material should be disclosed in the specification. Moreover, there should be clarity that whether the source has to be deposited or the recombinant has to be deposited. I understand, sir.
Okay. So, like, have you discussed about the Convention on Biological Diversity and Nagoya Protocol obligations?
I have not discussed, but I have mentioned it that the ethical considerations are taken care of by because India is having Indian Biological Diversity Act in place. However, I have not touched the ethical considerations, sir.
Okay, then take it as a recommendation that you should add those, and like your study should impose in relation to the Nagoya protocol because it will get more relevant to your subject matter. And the second recommendation was to WIPO standing committee on the laws of patent, like how the standardizing committee plays a role in the patent disclosure norms, deciding the rules and regulations for the patents.
Yes, sir.
You have
Yes,
to
sir. I
make the
understand.
assessment on these regulations.
Oh,
All right.
sure, sir.
Thank you.
Thank you, sir. Thank you so much. Thank you.
Okay, Manik, we can conclude it now. And specifically for the audience who are like with us for long. So, South Asian Global IP Summit 2025 is going on. And for like last 2 months, we are continuing with various events. Part two, that is the technical session two of the International Conference on SEP and Patent Innovation 2025 is scheduled next week. And I believe all of you, those who are continuingly supporting the organization as well as the summit, will be in touch and stay connected with us with your more dedication towards intellectual property and making the country as well as globe towards following the IP norms and making accessible to all. Thank you, all of you. Thank you, host and the organization.
Thank you, sir. Thank you to the organization.